I beg to mention item number 7, Lordship. I pray for 3 weeks' time.
What is the reason?
Reason is yesterday my senior was left for Delhi, Lordship, for the treatment of his wife,
Who is your senior?
Mr. BK Jain.
These are matters where no adjournment is to be granted.
Actually, Lordship, I have obtained the consent of the other side, Lordship.
Consent is defined in e-material.
Actually,
You wait.
much.
May it please your lordship, I beg to mention item number 15. My senior,
Item
Mr.
number?
15, Mr. Raju Goswami, my senior counsel, his son has been expired and he's,
Okay.
I'm appearing on behalf of the appellant and we have taken the consent. Lordship may kindly adjourn the matter for 3 weeks.
Miss,
D. Goswami on behalf of R. Goswami.
when his son expired? When his son expired?
July.
Miss
D. Goswami.
G. Goswami, Learning Council, for the appel, has submitted that Mr. R. Goswami, who is leading her in this case, is presently in bereavement due to demise of his son. So it is submitted that and they have sought listing of the appeal after
3 weeks, lordship.
3 weeks. Post of which is submitted that consent has been taken from the Learning Council for the respondents to interfere. Post of in view of the grounds cited for adjournment, court, the request for adjournment is allowed. Leaves the case after 3 weeks on a date to be fixed by the
Thanks, Lord.
police.
May it please your lordship. Lordship, in regard to item number 8 to 13, lordship, I am for the respondent
Will
number
not
4. my
hear.
lord.
My lord, in item number
Will hear.
22, we have filed an impleadment petition, my lord. That might be that.
Impleadment. Yes.
Also,
And numbers 8.
13.
Lordship, in item number 8 to 13, we are for the respondents and Mr. R. Goswami's son has expired, Lordship. We are for the respondent number 5 in this case.
What is there any liability on the part of Mr. R. Goswami? Respondent?
There's no
Insurance?
such- Yes, yes.
No liability?
No liability.
No liability?
My lord,
No.
20% liability was imposed upon me.
No, we have a mandate.
My lord, I have a small, I have misplaced my file, my lord. So
You go through the files. That cannot be. This is listed earlier. No, adjournment slip was also issued earlier. Yes.
I'm praying for listing of a motion matter tomorrow, Lord.
Subject?
Subject Lordship, we are the Gau Panchayat, Your Lordship. We want the market to be demolished so that we can construct a new one. We have written to the CEO of the Jila Parishad plus the District Commissioner, Your Lordship.
Is it so urgent?
Lordship, not so urgent, Lordship. It is a case of.
Get it listed. There are so many eviction.
Lordship, understood.
Normal course. Had it been eviction matter, I would have
Lordship.
allowed.
Daily list for motion, item 1. We find before troubling our lordships with the merits of the case order. Exactly in a similar matter, this is the order which your lordship has passed. Same facts, my lord, same section 111(2) and 64(2)(4).
Yes, Mr. Chaudhary, in this case, that is not the pleaded case.
No, my lord.
So far as non-submission of inquiry report, right? Is it a pleaded case?
No, my
Pleaded
lord,
case
take it-
is because that is why I have kept it today, because I think Mr.
But in-
Hussain.
But in any case, my lord, I think the matter has to be referred to a larger bench.
Uh,
Because your lordship's view is that the power can be exercised by the competent authority. But
no,
our-
not my
the
view
case
is not that. My view is already there.
in that 2019 judgment.
Thereafter, that has been affirmed by division bench.
Yes.
And that has been affirmed by Supreme Court.
Well, no, it's not been affirmed
And
by Supreme Court. SLP has been dismissed.
SN dismissed. So there is a line of decisions
Yes.
and which has not been discussed in the subsequent set of decisions.
No, look, there is a division bench judgment that I'd like to place.
And no, prior to that,
Hmm.
prior to my set of judgment, the
Yes.
earlier set of judgments, the virus has been upheld.
No, well, look, I think essentially the issue is, in my humble understanding, subject to what your lordships may say, whether it is a case of improper acceptance of nomination, in which case only an election petition is the remedy. And or alternatively, my lord, whether in terms of the notification of the government, whether the power of to cancel an election can be set aside by the competent authority as described in section 62.
Because there is a judgment
No,
of
my lord, section 62 starts with this word subject to the provisions of this act.
that is why there was a similar set of provisions, statutory provisions in the state of Haryana. That is, Supreme Court virus was challenged on 5 grounds. There, instead of deputy commissioner, it was director who can remove Javed. Javed virus has been.
No, I follow. But my lord, difficulty is on the other side also that there is a view of the division bench. That's a perhaps. my
No,
lord, it has
perhaps
to
it
be-
could be a par incuriam also. We'll examine.
Yes.
It could be a par incuriam.
No, I was only trying.
And
to place-
secondly, there is a small distinction in both the cases. The decision which has been decided by the cordial bench is in respect of a person who was a contestant.
Huh.
Here is a case who was an elector,
Elected.
voter. And Supreme Court says for a voter, he cannot be left remediless.
Remediless.
Section 127 read with
Remediless does not mean, my lord, he cannot file an election petition. He can also file
No,
under.
that is a bar.
Under section 81. Under
No,
section 81.
that is
of the
RP
RP
Act.
No, and by virtue of rule 44Z, the provisions of the RP Act has been made applicable here.
Where?
Yes, yes. Rule 40, my lord, rule for, one second. 45Z. Z2. Z2. Without prejudice to the foregoing provisions, wherever no specific provisions are made in this rule, the provisions of conduct of election rule so and so and the Representation of People's Act 1951 shall apply from time to time, and the instructions, statutory orders and clarification issued by Election Commission of India shall mutatis mutandis apply for the cases under these rules.
So all these are to be examined.
Yes. No, I'm
It
not
is,
saying.
it is,
Well,
not
there's
that,
one division bench judgment, if your lordship kindly permit me to introduce. This is again a DB judgment, Miller. Nino Begum to court of the. One second, I think we have given a wrong judgment. Nino Begum. I'm sorry, Miller. So many judges, Miller, will have to properly.
That is why we say that we will examine this issue.
No, my lord,
But
correct.
we have to examine this issue.
Yes.
We are not foreclosing anything
Right.
because I am also have to indecisive which line is to be followed.
To reconcile with the Miller.
Yes. and I am not in a position to refer the matter.
Before lordship takes a call.
Yes.
Correct.
And secondly, normally previous judgments or some rules are not.
I think in your lordship's earlier judgment, the fact that it can be only an person who has participated in the election, that is a consideration which weighed heavily in that case. I've gone through that judgment also.
But there are other judgments of Supreme Court
Yes.
that an elector cannot be
In all
elected.
situations.
And here, by notification, the state government has restricted
Election
election
petitions.
petition only to a contestant.
But
They
that
are
is
meaning
again-
thereby, in a constituency having 10,000 electors, all the others are except two.
Well, I think, my lord,
Maybe we don't
how-
know.
When a field
We
is
are
covered
the
by
only
statutory
threshold.
rules, when a field is covered by statutory rules, how executive fiat could have been issued, that is also an aspect which
That
lordship-
virus 62, Rule 62 virus has been upheld by division bench. And those are not referred to. Had it been referred to, Mr. Chaudhary, had it been referred to, I would have no difficulty.
Anyway, my lord, there are, issues which needs to be gone into on either side.
It could
If
be
lordship should
whether
kindly come to para 25 of the judgment. My lord.
25 of his judgment.
Para 25, page 9. The first subpara. The consequence would be the creation of two parallel jurisdiction, one before the election tribunal,
Para?
para 24, Miller, part of para 24. At page 9. First subpara. The
I have read. I have read it.
Yes.
But when 62 virus have been upheld by the division bench, and how can it, this court can say, another subsequent division bench can
That's
say,
why,
that has been upheld by Justice.
that's why, Millard, I was of the view, sorry, it's my subject, not view, that I think perhaps the matter has to be referred to a three judges bench.
How can I do it?
So lordship can refer it to because of all this.
No, otherwise, law is also clear. I have to follow that if some statutory provisions are not discussed and earlier binding, earlier judgments
Was not taken note of.
of bands of equal strength is not considered,
Ignored.
then
Per incurium.
for me, this is the, if somehow you can take it, I have no issue.
Correct.
If you can take it to a division bench or to a larger bench, no issue.
Now, my lord, I was only thinking whether your lordship would like to follow this order which your lordship has passed in exactly similar manner.
But that is not the pleaded case. I tried, Mr. Chaudhary, in 2-3 cases.
If your lordship will kindly come to para 8 of the writ petition. 5, sir. That the petitioner begs to state,
Just a minute.
page 7.
Petition is
That the petitioner,
one minute.
One
Petition
second.
is lost. Petition is lost. Just a minute. With so many judgments.
in fact, when my learned friend came to me the other day, I was also lost, my lord. He was referring to this judgment, that judgment.
Yes. Yes.
Para 5 at page 7. That the petitioner begs to state that all of a sudden the respondent number 4 issued the impugn order disqualifying the petitioner and removing her as ward member of so-and-so, treating this seat as vacant. It is stated in the impugn order that action has been taken on the basis of an inquiry made by the Assistant Commissioner Dhubri on a complaint received from one Ashraf Ali. Though the detailed report of the inquiry operator was sought for, but same was denied by the authority. From a reliable source, the petitioner came to know that while making the complaint by Said Sri Ashraf Ali, a purported offline birth certificate of daughter of the petitioner was submitted, wherein date of birth of the daughter of the petitioner has been wrongly recorded as 22/6/20, which is also mentioned in the impugn order. So that inquiry report was not given, their pleading is there.
Are not given, but there is no pleading regarding prejudice. Problem is that
Anyway, we can file an additional affidavit in that case.
if you are ready, we can get it listed subject to Mr. Dotto, and I think he'll be ready to file the counter.
Huh.
But Dotto,
Well, in that case, let them file their pleadings considering the urgency in the matter.
yes.
Lordship can have the matter on next Tuesday, my lord.
Well, I have some submissions, my lord, regarding the judgments, my lord. I have gone through, my lord, properly.
My lord, the lordship has the Javed case, my lord. That was virus was challenged, my lord, and that was upheld, my lord, and that is not dispute in this case, my lord, actually. And lordship's case, my lord, the Matiu Rahman and division bench also, my lord. The issue is, my lord, whether subsequent, my lord, to acceptance of nomination is acceptance or not. In those cases, my lord, the facts is that, my lord, after the acceptance of notification, my lord, the nomination, my lord, the clauses were violated. In all the cases, I have gone through it, my lord. And in some cases, my lord, in that series, my lord, some of the candidates have child after the notification date. That is why they have challenged the virus, my lord, that the act should be prospective in nature, so we should be allowed. The Matiu Rahman and the other series cases. In the division bench, only Matiu Rahman that was challenged, my lord. And in that case also, my lord, the violation was subsequent to, my lord, acceptance of nomination.
No, here the distinction is the complainant here
My lord,
is an elector.
my lord, my lord, my lord.
The other second set of judgment, where from the second set of judgment has arisen, it was a contestant, and that was the view that he could have raised the objection at the time of nomination itself,
My lord, my lord.
right?
Right.
And when it goes to section 127 or 243O
My lord.
or 127 and 129, then state government has restricted
Through the nomination, notification.
election petition only to a contestant,
My lord.
so that the election tribunal will not have jurisdictional fact to decide on the matter, because jurisdiction is a legislative function, conferment of jurisdiction. That something has to be rendered here so that you can either side.
My lord,
Otherwise, I cannot send
correct,
it.
sir. No, my lord, all that I am trying to submit is, my lord, let the matter come up
Let
on
the
next
matter be
Tuesday.
examined.
Next Tuesday, my lord. In the meantime, let me also go through all the judgments, my lord. I have just.
You will submit on law point, then
My lord, yes.
No,
no
there's
issue.
nothing like affidavit. It's all
Yes.
law point.
Only
Let
law
him, let
point.
him submit. This man submit, complainant.
Yes.
Let him file the affidavit. Otherwise, he'll be aggrieved again.
Yes, sir.
But Mr.
And if
Dot,
necessary, we'll also file an additional.
Mr. Dotto can also, he can say that I'll argue on law point.
Yes.
But so far as him is concerned,
Yes.
otherwise he will say prejudice.
Well, he is a private party, so there is no difficulty till the
Ah.
next Tuesday. A lot of time.
He can file.
Yes, ma'am. I'll submit only on law points. I'll try.
Ah. Next Tuesday is 18. Okay. Then we will not read much into it.
Keep it as item number 1.
Yes, sir. The series is Supreme Court. GST over, right? Supreme Court is a series that is huh? Because nowadays Supreme Court gives direction.
Okay.
There is one set of income tax matters. I know.
Our lordship can keep our matter at 2 o'clock.
Or 20 if
That
possible.
that they will decide
Yes.
at
in the
10:30
morning.
or 2 o'clock,
Yes.
subject to.
Lordship will give us the liberty to make a mention. Yes. That's nice.
On 20th, my lord, Thursday, next Thursday. 18th of Bhumika matters.
20 also no problem.
Better to have 18.
Okay.
18, I have some difficulty, my lord. I have some difficulty.
It will spill over.
We'll
We'll
see,
hear
Lord.
Mr. Chaudhary.
Yes, Bill, I'll start.
You will make submission on law points. What are the judgments? We'll just mention here. Heard Mr. Kain Chaudhary. Senior counsel listed by Mr. M.I. Hussain. Learned counsel for the petitioner. Please take your seat.
Lordship's kind permission, can I take leave?
Mr. S. Dotto. Learned standing counsel, Panchayat and Rural Development Department. Yes, Mr. Dubey, you have to say something. Sure, you assist. And Mr. Dotto, you have the responsibility
Well.
to prepare two lists. One in favor of the petitioner, the other in favor of the private respondent.
My lord, I will not prepare for any kind of favor, my lord. My lord.
No, what are the
Yes, yes,
judgments
my lord.
in favor of the petitioner
Yes, sure.
and
my,
against the petitioner?
my lord.
Two lists.
My lord.
Otherwise, if you give 20,
My lord.
then out of that, I have to pick up 1, 5, 7, 8, then it will be difficult.
Only second judgment have some difficulty. Otherwise, I have already gone through it. I'll prepare a list, my lord.
Because your duty
Yes. I'll
Yes.
try my best.
first
My lord.
to submit
My lord.
as regards Assam Panchayat Act,
Yes,
and thereafter the rules.
my lord.
Thereafter, thirdly, the judgments.
Yes,
It is your duty.
my lord.
They may refer to judgments.
My lord.
1, 3, 5, 6. Mr. R. Dubey. Standing House, Assam State Election Commission for the respondent number 2. Miss M. Bormon, Junior Government, Bogor, Assam. And you are the person who has the authority to remove. So you have to address the court. And Mr. H.R. Ahmed, Learned Counsel for the respondent number 7. Post of para. There is a case of the petitioner that being eligible, she submitted nomination papers for the post of ward member from ward number 7 under 25 Gutipara Gaon Panchayat in the Panchayat general election. That's 2025. Post stop. 2 other candidates also submitted their nomination papers for the same post. Post stop. Thus, there were 3 candidates for the post of ward member from ward number 7. Post. The polling of votes. The polling was held on 7/5/2025. And the counting was completed on 11/5/2025. Post of thereafter, the results were declared on 11/5/2025. And the respondent number 4 as the authorized officer issued the winning certificate to the petitioner, as the petitioner secured 422 number of valid votes as against 205, 271 and 205 now votes secured by the other two contesting candidates. Full stop. The respondent number 4 administered oath of office on 9/7/2025. Full stop. Para. The petitioner stated that on the basis of a complaint lodged by the respondent number 7, the petitioner was called for a hearing in the office of the respondent number 4. By way of a notice for a hearing on 9/2/2026, by way of a notice dated 6/2/2026. Full stop. On receipt of the notice, the petitioner appeared and submitted all relevant documents to the respondent number 6 by way of a letter dated 17/2/2026. Full stop. Para. What is the order? In this writ petition, the petitioner has assailed
It's 27.
an order dated 23/7/2026, passed by the respondent number 4, whereby the respondent number 4 purportedly exercising powers under section 111 within bracket 2 of the Assam Panchayat Act 1994, as amended, and Rule 62 within bracket 4 within bracket small b and within bracket small c of the Assam Panchayat within bracket Constitution bracket close Rules 1995 as amended. The petitioner is held to be disqualified to continue as a ward member in a Gaon Panchayat, and the petition has been removed from the post of ward member of 25 Gutipara Gaon Panchayat with immediate effect. Post of. It is further observed that the seat is to be treated as vacant thenceforth. Para. Mr. Yes, Mr. Hussain, what are the the first contention among the number of contentions, amongst the number of contentions articulated by Mr. Chaudhary Lion, Senior Counsel appearing for the petitioner, is that the respondent number 4, that is the jurisdictional district commission, does not have the power, authority, and jurisdiction to pass the impugned order under the provisions of Section 111(2) of the Act and Rule 62 of the rules. Full stop. It is mentioned that the issue, where is the judgment? Ayesha Khatun. It is mentioned that the issue has been settled by a decision of a coordinate bench in the case of Ayesha Khatun versus the state of Assam and 5 others, 2026, 3 GLT 102, which judgment has been upheld by judgment has been followed. What is 6284?
60, Joinal, I mean, it's a different case.
Second case is 5686, 2025.
5686.
It's Minu Begum. Minu Begum is 568.
Firdous Rahman.
আমার ভিতরে, হ্যাঁ? Minu Begum.
No, my lord. Firdous Rahman Mazumdar.
Do you have a
5686.
copy?
Yes, I have my copy.
Lordship, in this land, we have forwarded the Minu Begum judgment, Lordship.
The Minu Begum I have seen,
Yes.
but this Ayesha Khatun was not directly in challenge.
Yes,
It was Minu,
Yes.
the second one which has been challenged.
Yes.
Which decision was followed in the case of in another petition.
In fact, my lord, this case was also appeal has been filed. Now it's pending.
Which decision was followed in another, in the case or in another petition, WPC number 5686/2025 within bracket Firdous Rahman Majumdar versus the state of Assam and others. Bracket close, decided on. Oh, I go to decided on 13/3/2026. Agor 2 Ayesha Khatun decided on 23/2026. Full stop. The correctness, sorry, the decisions rendered in the aforementioned 2 decisions are upheld by the division bench in a writ appeal, writ appeal number 174/2026 within bracket Minu Begum versus the state of Assam and others, decided on date 8/6/2020. Posto. Au contraire. Para. Mr. Ahmed. Learned counsel appearing for the respondent number 7 has submitted that. Which one?
One is Mutur Rahman.
It was reported.
Mutur Rahman is reported me.
What is the citation?
Citation.
Has submitted that the issue is no longer res integra. The what is that? Yes, the virus of virus of Rule 62 in the Assam Panchayat Constitution, within bracket Constitution Rules 1995, which was inserted by the Assam Panchayat within bracket Constitution, within bracket Amendment Rules 2018. Challenge to the virus was negated earlier by a division bench of this court in WPC number 510/2020 within bracket Ayesha Begum, both Ayesha Begum versus State of Assam and others. Was it challenged? Find out. Because people nowadays go to the Supreme Court very easily. The issue is also settled by the Honorable Supreme Court in Javed and others versus State of Haryana and others. Because AIR, Supreme Court silo. AIR 2003 SC 3057. Which was wherein the virus of similar provisions in the Haryana Panchayati Raj rules were challenged. He has further referred to a Motirama citation.
Citation is, my lord, 2022 4 ZLR 25.
He has further submitted that the issue involved hearing was under consideration
SEC online.
2022.
2022 4 ZLR 25. Or SCC online citation is also there,
Okay,
my
it's
lord.
okay. In the case of Motiu Rahman, in a batch of writ petitions, including Motiu Rahman versus the State of Assam and others, 2022, 4 GLR 2025, oh sorry,
25, only 20.
Which was decided on 7/12/2025. Full stop. He has submitted that the decision, the judgment rendered in Motiur Rahman was challenged before the division bench in a writ appeal writ appeal number 45 stroke 2022, which was dismissed on 24/02/2022. Full stop. The said judgment and order of the division dated 24/2/2022 of the division bench was challenged in special leave to appeal within bracket C number 7079 2022 before the Honorable Supreme Court. First of the Honorable Supreme Court dismissed the SLP by and did not interfere with the order passed by the High Court. While its order dated 6/5/2022. Full stop. The in both the sets of judgments, the provisions of section 111 2 bracket of the Assam Panchayat Act and Rule 62(4) of the Assam Panchayat Constitution Rules fail for consideration. Full stop. On a look, full stop. The sets of judgments, both the sets of judgments have considered the provisions of section 127 and section 129 of the Assam Panchayat Act, as well as Article 243 capital F of the Constitution of India. Any other provision?
Lordship, in earlier cases, my lord, it's not 62-4, my lord. It's 62, only 62-1, my lord. In earlier judgments, my lord.
Oh, it said only 62 now for the timing.
Yes, 62 is.
Because entire 62 virus has been upheld.
Lordship has said 62-4, my lord. Okay, it's not 62-4.
62.
Only 60.
The Learned Counsel for the parties have also drawn attention to a distinction in the two sets of judgments in that in the Motiur Rahman, anybody elector?
No, my.
All defeated candidates?
Yes. In fact, in some cases, my lord, they seek directions from this honorable court so that the nominations can be accepted, my lord. Because they have already more than 2 children.
No.
Motiur,
Panchayat Motiur.
This series, my lord.
The petition stated.
And only Motiur Rahman challenged before division bench. Motiur Rahman's child was born after the acceptance of the.
No, we are not into facts.
Yes. All are candidates.
And other provisions. And other provisions of the refer to the provisions of various provisions of the Assam Panchayat Act as amended, more particularly X section. And the provisions of the Constitution of India, more particularly Article 243F. First, a point of distinction in that in the case of Ayasa Khatun, the complainant was a contesting candidate, whereas in the case in hand, the complaint is an elector. You are an elector, not a contesting candidate. Does from the above two sets of judgments, primacy to distinct, to different scenario have emerged, which require a detailed consideration. Full stop. Land counsel for appearing for land counsel appearing for all the parties have submitted that the matter requires expeditious consideration. And since all the parties have entered appearance, the repetition can be heard at an early date. Post. Having regard to the issues and considering the urgency expressed by the land council for the parties, issue notice, let notice be issued. Full stop. As sought for and agreed to by the land council for the parties, the notice is made returnable on so and so date, 18. Full stop. Mr. Hussain, land council, preparing for the petition, shall furnish a requisite number of copies of the petition along with annexure to so and so, so and so, so and so during the course of the day. First up, the respondents, official respondents, as well as respondent number 7 shall file their response before the next date of listing. So, having regard to the issues raised, an endeavor will be made to give final consideration to the petition. Endeavor will be made for expeditious consideration of the petition. Huh? Any other judgment?
My lord, I have found one Supreme Court judgment. I am just submitting to the lordship. Obliged.
Supplementary list, item 20.
Yes. Registration. What is the service? Composite. Composite.
Yeah, NOC.
NOC or composite land sale? Let us see the composite. Pending or disposed? Application?
Application pending.
Pending.
Your lordships is relying on that annexure 8 page 37. This is the notification.
8 page 27. We have the.
Yes, Lord.
Say so.
Today your lordship is going to dispose of them.
On last occasion, your lordship relied on page 36, the vernacular, where the circle officer's report has already been submitted before the deputy commissioner 1 month back.
Heard Mr. J. Abedin. Counsel for the petitioner. Mr. A. Aforesaid. Standing counsel, revenue and disaster management department for government of Assam for the response number 1 and 2. And Mr. H. Sharma,
3, 4, 5.
additional senior government of Assam for the response number 3, 4, and 5. Para. The petitioners, scoring number, have joined together to dispute the instant petition under Article 226 of the Constitution of India, stating that they have a common cause of action to espouse post of. The petitioner number 3 is the wife of one late Koilan Sondro Soprobody. And the petition number 1, 2, and 4 are the sons of late Koilan Sondro Soprobody. It is a case of the petitioner.
My lord,
Petition.
1 and 2 are of late Kiran Chandra.
Huh?
Kiran.
Is it? Okay.
Third brother is the Killan.
Okay, one.
3 and 4 are Killan.
The petition number, the petition number 1 and the petition number 2 are sons of one late Iran Sondro Soprobody. Whereas the petition number 3, the petition number 3 is the wife of one late Koilan Sondro Soprobody. Whereas the petition number 4 is a son of late Koilan Sondro Soprobody. Late Kiran Sondro Chakraborty is the father-in-law of the petition number 3 and the grandfather of the petition number 4. That's they have stated that all the petitioners belong to the same family. It is further stated that late Kiran Sondro Chakraborty owned a parcel of land, owned 2 plots of land measuring 7 bighas, 3 kathas and 2 bighas, 2 kathas, that is, total, that is 10 bighas in total. The said 2 plots of land are covered by tag number 87 and tag number 89 under periodic patta number 8 and are located at village 2 number Jukuta Kisamot, Kampur Revenue Circle, Mauja, Jorabari, District Nagaon, Assam. Subject plot. How much? All entire? Entire?
Total 10 bighas.
No, you want to sell?
Sold already agreement.
Okay, fair enough. The petitioners have stated that after the death of late Kiran Sondro Chakraborty, the subject plots are inherited by the petitioners. And accordingly, their names stood mutated in the revenue records. So the petitioners have stated that they have been paying land revenues regularly and have been jointly enjoying peaceful possession of the subject plots. We're jointly enjoying, which are agricultural lands. Post of para. The petitioners have further stated that the petition number 4 has been suffering from various illnesses like paragraph 5. Right, good. Rakhi. For the last 2 years, and he has been taking regular medical treatment at different medical facilities, including different medical facilities. Post-op. As per a medical certificate issued on 36/2026 by a registered medical practitioner, annexed to the writ petition as Annexer 1, the petition number 4 has been advised to take better and advanced treatment outside, preferably in Apollo Hospital at Chennai, Tamil Nadu. Post-op. It is averred by the petitioners that in view of medical treatment of the petition number 4, there emerged an urgent requirement of a substantial amount, and in order to collect the required amount for the medical treatment of the petition number 4, the petitioners decided to sell the subject plots to a willing purchaser. Post-op. After search, one Sri Jamaluddin, a resident of village number 2, Jukuta, police station, Kochua district, Kamrup, came forward to purchase the subject plots at an agreed sale consideration at rupees 1,50,000 per week. Post-op. Thereafter, the petitioners executed an agreement for sale of land with a proposed purchaser on 24/6/2024. And at that time, the proposed purchaser paid an amount of rupees, amount of rupees 10 lakh. After execution of the agreement for sale of the subject plots and receipt of the advance amount from the proposed purchaser, the petitioner submitted the petitioners through the petition number 2 submitted an application online on 29/1/2026 in the designated portal Seva Setu for delivery of the notified public service, quote, composite land sale transfer and the receipt of the said application was duly generated on 29/1/2026 itself by acknowledgement number, page 29. Page 29. Para. And the petitioners tried to find out the processing of the applications. Processing of the application. By an application, through an application dated 13/5/2026. Okay, when? Oh, sorry, as per the said application acknowledgement. In the application acknowledgement, it was mentioned that if the application was accepted by the Revenue and Disaster Management Department, the service would be provided within 45 days, within bracket, excluding the time taken between issue of NOC and presentation of sale deed before jurisdictional sub-registrar office, bracket, and the applicant could raise an appeal if the service was not delivered within 45 days. Full stop. Para. When, despite elapse of the stipulated delivery date, the public service sought for by the petitions was not extended. The petitioner submitted an application before the respondent number 3 on 13/5/2026, requesting requesting expeditious processing of the application, as the petitioners were in need of urgent money urgently for the medical treatment expenditure of the petition number 4. Close stop. Para. Subsequently, the petitioner came to learn that the respondent number 5 had submitted a report on 18/6/2026 before the respondent number 4, reporting that the subject plots of 10 bighas are recorded in the name of the petitioners as patadars, and during field verification, it is found that the petitioners are in possession of the subject plots. In the report dated 18/6/2025, the respondent of 5 has also reported that the reported about the region for selling the subject plots to the proposed purchaser. It is further reported that the adjoining, the residents of adjoining lands. Although it is further reported that the government Gambura has certified that the neighbors would not have any problem if the sale permission is accorded. Those are para. These are the facts. Yes. Eight. Mr. Abedin, Learned Counsel, preparing for the petitioners, has submitted that since the service, composite land sale transfer is a notified public service under the Assam Rights to Public Services Act, and in view of Section 21 of the Registration Act 1908 as amended, it is incumbent on the part of the respondent authorities either to allow the application for the NOC for sale or to dispose of the application by way of a region order within the prescribed delivery period. It is not open for the respondent authorities to keep the application pending for such prolonged period. So we have submitted that the petitioners had submitted the application fulfilling all the requirements. Post up. Yes, further submitted that the intended transfer is governed by the standard operating procedure notified by the Revenue and Disaster Management Department, Government of Assam, by a notification dated 9/9/2025, even if the intent transfer. The period of delivery of the notified service is one month or 30 days. Post para. There. 12, 13. 14. Within a period of 30 days, that's on the date of submission of a copy of this order at the office of the District Commission.
May I point out one thing, Lordship? The letter from the circle officer is dated 18/6 2026 at page 30.
18.6.
Your Lordship, I think it's 25 years.
Okay, 18.6, huh? Page 36.
My lord, there are small two, three. One is initially when your lordship that fragmented the land, 8 bigas, 3 katas and 2 bigas, 2 katas. I think possibly, word 8 bigas have come total. It should be 10
Okay,
in the beginning.
okay.
Then
Into paragraph 3. 7 biga, 3 katha and 2 biga, 2 kathas. That is 10
10
bigas in total.
My lord, then another, I think it is medical certificate is 36 2026.
Okay. 36. Hello, huh?
My lord, another thing, your lordship has mentioned the name of the purchaser is Jamaluddin. Actually, it is Saiful Islam, son of Jamaluddin.
Okay, okay. Okay, Saiful Islam likhle.
Yes.
Saiful Islam. Resident of village number 2 Jokuta Kosua. Huh? Okay.
Yes.
Saiful Islam.
Yes, ma'am. Deeply obliged, ma'am.
Item number 21.
Your Lordship has dealt with a similar matter. I
Yes.
thought that only the difference is that in that case, 3 and 4 was issued together
Together.
and appeal was permitted to be preferred. Here, after 3 was issued, we have preferred an appeal. Appeal is
Not
pending,
disposed of.
not disposed of.
Let me get the instruction from the department whether the appeal is, any order has been passed in the appeal or not. And can it be posted in the next week? Till then, they may be protected.
As Mr. D. Hanapati, Learned Counsel for the petitioner. Mr. A. Aforesaid, Learned Standing Counsel, Revenue and Disaster Management Department.
For 1, 2, and
Assam
3.
For the respondent number 1, 2, and 3. And Mr. N. Das, Learned Junior Government Advocate, Assam for the respondent number 4, 5, and 6. Para. The petitioner has approached this court. Agreed by. and
Page
order.
34.
Agreed by.
Next,
Page
Page 44.
40.
appeal to give more instruction. Anand.
Agreed by an order issued in Form
Form C.
C.
Rule 5
As per Rule 5,
and Section 4(1).
as per Section 4 within bracket 1 of the Assam Land within bracket Requisition and Acquisition Act 1964. 1964 for short, read with Rule 5 of the Assam Land Requisition and Acquisition Rules 1964.
Yes, Your Lordship.
Okay, 1964 rules. Whereby a parcel of land measuring
211
211
bigha, 1 kotha, 19 lasa.
1 bigha 19 lesa has been has been sought to be taken over.
Yes.
Full stop. The petitioner, being the owner in occupation of the said parcel of land, has been directed to surrender or deliver possession of the possession to the circle officer. His respond number? To the respond number?
6.
6, being the person authorized by the
Collective.
respond number 4 within 10 days from the date of service of the order for the purpose of acquisition of land for setting up industrial estate of Numaligarh Refinery Limited. This is date. What is the
Next page, Your Lordship.
28/7/2026.
Yes. 20th.
Paragraph. The impugn order dated 28/7/2026 was preceded by
Page 34.
an order dated
6/5.
6/5/2026
Yes, sir.
in Form B under Section 3(1) of the 1964 Act, read with Rules 4 of the 1964 rules. Full stop. By the said order, the respondent of 4 what is the provision?
Section 3(1).
Requisition.
Yes.
The parcel of land with effect from the date of the order for the purpose of acquisition of land for setting up of the industrial estate of Numoligarh Refinery Limited. Full stop. Para. It is the case of the petitioner that agreed by the issuance of the order dated 6/5/2026. The petitioner had preferred an appeal
Page 36.
before the state government on 29/5/2026 under Section 3 within bracket 3 of the 1964 Act, seeking what?
Seeking for setting up this order.
Containing that the provisions of Section 3 within bracket 1, the condition precedent are laid down in set forth in Section 3(1) of the 1964 Act is not met before for issuing the order dated 6/5/2026. It is the contention of the land council for the petitioner that without the final decision in the appeal taken by the state government, the respondent number 4 as the collector could not have issued the impugn order dated 28/7/2026. So as the appeal preferred by the petitioner before the state government on 29/5/2026, the impugn order is without jurisdiction. Mr. Aforesaid, learned standing also revenue and disaster management department appearing for the respondent number
123.
and Mr. Das also. 123 has submitted that he needs a week's time.
Till 18th.
18th. A week's time?
Right.
Today is what? 11.
11.
So week's time to obtain instruction as regards the status
Of the appeal.
of the appeal. Stated to have been filed by the petitioner before the state government on 29/5/2026. Full stop. Para, as in view of the above submission of Mr. Aforesaid, and considering the fact that by the impugn order dated 28/7/2026, a period of 10 days is mentioned for delivery of the stroke or surrender or delivery of possession of the requisition land, comma, it is observed that till the next date of listing, there shall not be any consequential action on the basis of consequential action for taking over possession of the requisition land, requisition parcel of land measuring so and so, so and so. Lease the case on. Here you
18, can it be 18?
18. 18 it is too much.
19.
20.
20.
Apply.
Regarding the status of the appeal will be brought by him.
Yes, yes, I'll
Regarding the communication, will not take any coercive action, will be made by him.
apply.
2008.
You inform.
Yes.
You need a copy of this order. As requested by Mr. Das, a copy of this order is to be supplied to him for taking necessary steps from his end.
Item 22.
Your impleadment petition has not come, my lord.
So before that, may I assert the fact? My lord, basically the impugn order has been passed for sealing of my the building, the petitioner's school building, my lord.
But the basic thing is that it was for residence.
I admit, my lord. But if your lordship will look,
And you have been running admittedly,
my lord,
not for residence.
I understand. But the purpose, if your lordship will look at the planning permit at page 48, my lord. This planning permit, my lord, just I'm reading only one para, my lord. With reference to the above application for layout of the development to erect, re-erect, add, alter, or a building at ward number so and so, planning permit is hereby accorded under section 5 of so and so Assam Unified Building Construction and Regulation of Bylaws 22, read section 4 of the Assam Construction Regulation Amendment Act 2022. In accordance with plans submitted without modification, the proposed area of construction falls under residential zone. But that doesn't bar to run an educational institution, my lord, to run a school.
Tell me.
Yes, my lord. In the Unified Building Bylaws, my lord, that is at page 20, the Act of 22, my lord, the bylaw of 22, there is an appendix that has been newly inserted on 2011-22-24, that is Appendix 11.
What is the book?
This is the big book.
Page number?
Page number 939. It starts from page 938, the appendix. So land use permissibility table, my lord. So these all are,
Yes.
these all are, means first the land used for R means residential, the index are defined at page
Let
947.
me explain first page 938.
My lord,
Explain page 938.
yes, that is the land
No,
used.
these are permissible uses.
Yes,
Permissible uses is one thing,
in residential zone.
right?
I understand.
Now tell me that you have got permission to use it to run a school.
My lord, that is right. But my lord, the order.
Tell
which-
me yes or no.
Yes, my lord.
Yes, you have,
No, my lord, there is no
no.
permission.
Then,
But my lord, there is no bar to run an institution.
no, bar, first you,
And before
No,
coming to that, my lord,
before that, it cannot be a condition subsequent.
my lord,
That you first run the school,
yes.
then you run here and there for
My lord,
permission.
But the
It
planning,
is a condition precedent.
but the planning permit has given
No,
in a
it is set
residential
up in,
zone.
no issue. It
My
is
lord,
set up in residential zone.
yes,
Master plan has mentioned what are the residential zone,
yes,
what are the commercial zone,
Yes.
what are the industrial zones, right? Then for industrial
So
zone, there
here
are
it's not specific.
many categories, 1, 2, 3, right, Mr. Dutta?
My lord, when
Right.
planning,
But question is, your house is in residential zone
yes,
where
a
it
school
is
has been running.
permissible to use the building
Yes,
for the permissible activities. That is, all these are permissible activities, right?
Yes.
You cannot run a brick lane in a residential zone,
yes,
but you can run a school,
in a residential zone.
but which is constructed for residents. If you want to change it, is it it will be commercial use?
No,
What use? Tell me which one. Tell me.
my lord,
Serial number. Serial number.
serial number 128.
In this.
Yes, in this index. That is-
Schools.
Yes.
Right.
That is, it's for both residential, for in mixed unit also, in commercial also.
Permissible.
So, and,
So how
and
to
this-
get?
and this planning permit,
How to get?
and this planning permit has been given only for stating the residential zone. Nothing is there, my lord.
How to get?
And while they have,
Suppose, okay,
and while they have passed,
just Mr. Decker,
Yes, yes, sorry.
just for example, come to 104.
104. Petrol filling station.
This is also permissible,
Yes,
right? So one can go and set up directly a petrol pump. Other compliances.
no, they,
Let the
they
this
will need,
license explosive. Let us keep it aside.
my lord, they will need a permission.
Whether without permission of GMD,
No, they will need a permission from another authority.
GMD or not,
No, not GMD.
not required.
Because GMD,
I'll record all these submissions then that for petrol pump also, petrol filling station, right?
my respectful submission is that GMD only issue
then
planning permit, my lord.
we can give you definitely permission
My lord,
to all these say taxi, bus stand, rickshaw
yes.
stand. GMD permission is not required.
My
We'll
lord-
record.
My lord, what I'm coming, my lord, GMDA can only issue planning permit, not the building permission, my lord. Building permission has to be given by the GMC, not by the GMD, my lord.
No. The use. Who will give the use?
That is by the GMC, my lord, not by the GMC.
GMC.
Yes,
GMC.
because building permission has to be given by the GMC, not by the GMD.
No. Firstly, under the GMDA Act, Mr. The zoning regulations
Yes,
are by GMDA,
yes, my lord.
right?
Yes,
Now it is a big book. It is not easy for me to find out the use,
yes,
provisions regarding the use,
yes,
unless the council assists.
my lord. Therefore, I'm coming. My lord,
Let us go to the straight way to that.
planning permission can be given by the GMDA, and the subsequent the building permission for
No,
the
if you want
purpose of
to point out, me to point out, okay, come to development. Definition of development. If you want me to point out,
and my lord, before
let us
my
have
lord,
the definition of, let us have the definition of development. Hold on, don't worry. We come back after 5 minutes. Let us have the definition of development, section 25 onwards or 23 onwards, and 87. We'll see first. The first is statutory provision.
yes,
right, statute, thereafter bylaws.
Yes.
Because bylaws are subservient to the statute. Yes, planning permit.
My lord. Planning. Lord, Before coming to the planning permit, my lord,
Hmm.
if your lordship will look at
Come
the,
to page 48. Planning permit itself,
yes,
a row tree.
use residential, my lord.
So, if somebody wants to change of use,
So they have to make an application before the ZMK. I've read. My lord,
if we go to the provisions of now, ZMD Act, what is development? Section 2(8). Making of any material change in any building or land or in the use of any building or land.
my lord, section 28.
No, section 2, subsection 8. Definition.
Yes, yes.
Making any material change in any building or land or in the use of any building. Right?
Yes.
Then the powers. 24, 23, 24. And 25. Permission for development. Any person intending to carry out any development
My lord, the permission of the school was accorded by the education department.
that
In the-
run the school,
Yes, my lord.
run the school.
Yes, my lord.
That they do not deal on use of the building.
My lord, I understand. But the whole stakeholders will be in difficult thing, my lord.
But for that, law cannot be banned.
Yes, I understand.
How he has
For
obtained,
that, I bow down, my lord. But the thing is that the whole
It
stakeholders.
is for that, for the others who suffer, law cannot be banned.
Yes, right, my lord.
Right.
Absolutely right.
But so far as I can have you to, because it is an appealable order.
Yeah.
You can prefer an appeal.
My lord,
page now 48, my lord, the planning permit. How he had obtained the planning permit? It is under a scheme. Lord Civil, the 2022.
No, scheme is by the owner of the land, who built the land,
And who, my lord, under
who built the
section,
building.
under section 9 of the Unified Act, 22. Lord Civil, kindly go through that particular act, my lord. Under section 9, it has come.
Otherwise, these are many factual determinations.
Because,
So we can have this, you can have an appeal,
yes, my lord.
and in the meantime, I can provide you some
Because
time.
there are, no, limitation is there. Another 5 days he have it. Because 30 days is limitation. Otherwise, that limitation will also go. And the Lordship has
Plus
passed similar.
the period spent in this appeal,
No, it was filed yesterday.
till
And
then, my lord.
that is a pre-existing judicial authority. That appellate authority also has the power to condone, but that will create trouble for him to make a prayer for stay.
My lord.
Right. So I can grant you time to grant liberty within the limitation period. Until that time, they shall not take any action.
Well, Lordship has passed similar order, I have it.
They think, because otherwise we go,
My lord,
I've expressed
I understand.
tentative view. So that court has the power to stay also.
Yes.
Let them stay. You lead evidence. Somehow,
Lordship has quoted all this, section 73 and 71, 73, all that chapter, entire chapter. Man.
okay. That notification also.
Yes. By that time, he can also apply for modification.
My lord, now,
To
yes,
give you space,
my lord, I understand. But now the
to
difficulty,
give you time, basically.
but my anxiety is that now the difficulty is that the already education department has issued a order, implement order dated 4/8/2026, my lord, for
That is not my roster.
yes, why,
That is not my roster.
because in the same building, my lord, now the difficulty is that if I have to change the building, then I also need to take permission from the education department. And that has been also stayed by this coordinate bench of this honorable court, my lord. So
I have seen. There is no reason. There is no reason. Simply state.
simply,
It is not a region order.
but the whole difficulty would arise, my lord.
If I pass an order either granting interim or not granting interim, I at least express my reason.
I understand.
So I cannot look into that.
My lord,
That cannot be
my
the
lord,
factor.
that aspect
That
also,
cannot be factor. Cannot be a factor for this court.
I vote on, but that may be also considered, my lord.
Now, you urge all the points.
My lord,
Observe that it is open for the petitioner to urge all the points before the appellate authority.
my lord, my lord.
Yes, sir, that's the
You
only
urge
way
all
of
the
saying.
point.
My lord.
That factor also you urge.
That may be observed. my lord.
Heard Mr. B.M. Deka. Learned counsel for the petitioner. Secondary education, you were there. But that IAS has to come.
I'm informed that that has been reported.
With that, I also, it lordship,
And
because
it has been
my
numbered
anxiety
also.
is that he has only another 5 days. Otherwise, that limitation will come.
We'll dispose of.
I have numbered.
Mr. Housing Arman,
Yes, my lord, 1 and 2.
Mr. S. Bora, Learned Standing Council, Housing and Urban Affairs Department, Government of Assam and Gauhati Metropolitan Development Authority, GMD, for the respond number 1 and 2. And Mr. U. Sharma, Learned Standing Council, Secondary Education Department, for the respond number 3. Post of para. Who is the impugn order?
Page 71, my lord.
In this repetition preferred under Article 226 of the Constitution of India, the petition has primarily assailed an order Please take your seat. Where is your prayer?
Lord,
Primary assail.
at page 16.
An order dated 15/7/2026. Passed by the respondent number 2. Whereby the respondent number 2 has ordered that the owners stroke occupiers and the management of Vivekananda Academy Senior Secondary School shall discontinue the institution use of the building and voluntarily seal the premises within 7 days from the date of receipt of the order. Full stop. আগৰ পৰা লিখিলো। It is the case of the petitioner that the petitioner school is a non-government educational institution and it obtained as on that no permission.
My lord, as that has
As
been
on it.
stayed.
Okay. And it has obtained provisional prior permission and provisional registration under the Assam non-government educational institution within bracket regulation and management bracket close act 2006 within bracket to the 2026 2006 act. And post up on the basis of such permission and registration under the 2006 Act, it has admitted students for imparting education from class
Trust, yes, my lord.
class 1 or what?
1 to 12, my lord.
Class 1 to class 12. Post up. Though for establishing a permanent campus, it had already purchased a plot of land measuring 5 acres at Revenue Village, Senabor, Mouza Dimoria District, Kamrup Metro, Assam. The permanent campus could not be set up in time due to various hurdles. Full stop. In order to operationalize the school, the petitioner school had taken a RCC building. How much? Z plus, within
G
bracket
plus
Z
two.
plus 2. Having an area of 7,000 square feet on rent at Beltola, Gauhati. Post up. It has also taken a plot of land measuring 10 lesas on rent for parking purposes. Post. Para. when the petitioner was served, where is the notice? Prior notice.
My lord, at page 766, my lord.
Petitioner was served. The principal of the petitioner school was served a notice on 2/6/2026 by the respondent number 2 under section 87 of the GMDA Act, the Guwahati Metropolitan Development Authority Act 1985, in bracket GMDA Act. Stay informing that the petitioner school is being operated in a residential building, residential RCC building, within bracket ground plus 2, permitted for residential use only. Posted by the notice, the respondent number 2 had directed the petitioner school to stop the operation of institutional use of a residential building and was asked to show cause as to why the alleged unauthorized use of the building should not be demolished under section 88 within bracket 1, or the premises in which the school is being run should not be sealed under section 88 within bracket 4 of the Act. Responding to the notice dated 2/6/2026, the petitioner school submitted a reply on 8/6/2026 explaining the reason as to why the direction as explaining as to why no coercive action, including sealing of the premises under section 88 of the GMD Act be taken against it. More particularly, in the larger interest of the students and for the cause of education. Post of. It is further mentioned in the reply that the petitioner school is making all sincere efforts to shift the institution to its permanent campus upon completion of the necessary instruction and the necessary infrastructure. After completion of the necessary infrastructure. Post of. Para. It is in such backdrop, the order, impugn order, dated 15/7/2026 has come to be passed. First of. In the impugn order, it is mentioned that in the event the petitioner school does not discontinue the institutional use of the building and voluntarily seal the premises within a period of 7 days, the authorities in the GMDA would proceed to seal the premises and take further action as deemed fit under the provisions of the GMDA Act and other applicable laws at the risk and cost of the petitioner and concerned parties. Para. Do. A number of contentions has been raised by Mr. Dekal, learned counsel appearing for the petitioner. While assailing the legality and validity of the impugned order dated 15/7/2026. Full stop. Para. On the other hand, Mr. Bora, learned standing counsel, ZMDA, has submitted that in order to the impugned order is an appealable order, and the petitioner, without exhausting the remedy of appeal, has approached this court invoking the extraordinary jurisdiction of this court under Article 226 of the Constitution. And therefore, this writ petition is not to be entertained. And he has further submitted that the petition is to be relegated to seek recourse of the statutory remedy of appeal, which is available under section
73. It's
70,
73 is the actual section to file the appeal.
73. No, chapter. What is a chapter? Under chapter,
Another chapter is 8. It starts from 70.
chapter Roman 8 of the ZMD Act. Full stop. Where I've considered the submissions advanced by the Land Council for the parties. And I have also gone through the contents of the notice dated 2/6/2026, the reply dated 8/6/2026, and the impugned order dated 15/7/2026. Full stop. Para. Dancing a small, yeah, dancing. On perusal of the provisions of the GMD Act 1985, more particularly, chapter Roman 8, it is found that the petitioner has a statutory remedy of filing an appeal against the impugned order dated 15/7/2026. First of para. Chapter Roman 8, para 9. Huh? Para 9. Para 10. What is the period of limitation?
32 for Note 72, subsection 2, all appeal of the appellate authority shall be filed within a month from the date of the appellate.
As per subsection 2 of section 72, an appeal to the appellate authority is to be filed within a month from the date of the order appeal against. Most of the time required for taking out the copies of the order is to be excluded. Most of. In addition, the appellate authority also has the discretion to condone any period of delay in filing an appeal for sufficient reasons. Full stop. Meaning thereby the provisions of section 5 of the Limitation Act is applicable in case of an appeal filed under chapter 8 of the GMDA Act. And therefore, and consequently, the provision of section 14 of the Limitation Act 1963 is also applicable. 2-3 days here.
2-3 days.
Close. Para. As the petitioner has the statutory remedy of appeal under the GMD Act, and as the appellate authority has been vested with all the powers of a civil court for the purpose of taking evidence on record or enforcing the attendance of witnesses, including the parties interested or any of them, and compelling the production of documents and material objections if considered necessary, apart from the power to condone any delay, the appellate authority can also determine any questions of fact which might fall for determination in the course of the appeal. Whereas this court, whereas in a writ proceeding, a determination of questions of fact whereas in a writ proceeding, whereas in a writ proceeding, the questions of disputed questions of fact is not to be decided, so that you can raise some factual question. As the period of limitation of 1 month has not expired and till date, and has not expired till date, and in view of availability of such adequate, efficacious alternative statutory remedy of appeal, this court is not inclined to entertain this writ petition. Post of reserving, and it is accordingly observed. Post of the petition, the reserve, reserving the liberty to the petitioner to avail the statutory remedy under the provisions of the GMD Act by filing an appeal before the appellate authority as expeditiously in an expeditious manner, preferably within a period of limitation. Post of para. It is further observed that if the petitioner prefers an appeal, the appellate authority shall consider the same by taking into consideration all the relevant factors. Full stop. It is further observed that if the petitioner makes any prayer for interim relief, the appellate authority shall consider the same on its own merits and in accordance with law. Full stop. It is the petitioner is at liberty to raise all grounds on law and facts before the appellate authority. So it is clarified that any observation made herein above shall not be construed as observations on the merits of the claim of the petitioner or claim of either the petitioner or the respondent authorities. Yes, anything?
Till the final disposal of the appeal, that may be stayed.
No, I cannot say. I can say that it is observed that since since that it is open for the petitioner. Since it is observed that the respondent authorities, more particularly the respondent number 2, shall not initiate any action against the petitioner till the expiry of the period of limitations of filing an appeal.
Till the disposal of the appeal.
I cannot.
It is the
This is against the law. I cannot. I could have said so. It is not possible.
I understand.
Anything to be further observed? So you urge the appeal in the interim period.
Much obliged.
Oh, I, okay. Otherwise it will be hanging. Heard Mr. B.M. Deka. In view of the order passed.
yes, sir. In view of the order, this is closed.
Heard Mr. B.M. Deka, and counsel for the applicant. S. Bora, standing counsel, Department of Housing and Urban Affairs, Government of Assam, and standing counsel GMD for the opposite party number 1 and 2, and Mr.
You Sharma.
You Sharma. Opposite party number 1, 2, and 3, 4, and Mr.
You Sharma.
You Sharma, and standing counsel so and so for the opposite party. In view of the order passed today in the accompanying petition, this interlocutory application stands accordingly disposed of.
Highly obliged, Madam.
Yes, Mr. Bora is gone. Should we allow this? Should we allow this?
The moment it is allowed, Malik, we'll have to find a phrase cost title.
As by the order dated. As by the order passed today. In the as the repetition. Always in our so and so has as by order dated so and so, it is observed that the accompanying repetition is not entertained. Comma, this interlocutory application is dismissed.
Much obliged.
Daily list for admission, item number 2.
Yes, Mr. Sharma, I'll dispose of
Yes, sir.
allowing you to avail the remedy so that you can challenge the judicial order.
Under 520 BNS.
And I'll record, yes. Okay. Only Dampira Liko. Have you gone through this Mahesh or?
Yes.
Mahesh Kumar Agarwal versus
And the other one, that Rita or Rina.
Punjab and Haryana High Court, my lord.
No, that judgment.
Rita Singh.
Rita Singh.
Rita Singh.
So, someone has been issued.
No, someone has not yet been issued.
Cognizance has been taken.
My lord, search sheet has been filed before the court, but
Tell me
it has not
the
been placed.
actual fact.
Yes, no, my lord. That someone has not yet been placed before the court.
No, cognizance has been taken or not?
Not, my lord, because had the cognizance taken, someone would be issued to us.
That is a different matter. I am asking. That is
No, my lord.
that is assumption and presumption.
Search sheet has not yet been placed before the trial court as yet. So, my lord, the cognizance has not been taken. Only it is deposited in the office in Judicial Magistrate Office in GD branch. Therefore, only we have.
Have
got
you
this.
tracked?
Yes,
Have you
ma'am.
tracked the cases?
Yes, my lord, we tracked.
Sarsin number I know. On the charge series of 2023, it cannot be said that
Not yet issued, my lord.
no.
Someone we have not received and they
No,
have.
I am asking you regarding cognizance. You may not have received summons
My lord,
for one reason or other.
my lord, my answer is, my lord, that search sheet has not yet been tagged with the case record event, my lord. It is in the office because we tracked it, my lord. We could not get it because probably, my lord, they were saying that it's on the shifting and all. It takes time these days. That is the explanation given, my lord.
Ms. Borman, can you see from Mr. Can you get the instruction? From the portal itself, that kiosk. Kiosk, kiosk.
I'm trying.
The police case number, police station case number and search sheet numbers are available.
Yes.
Right. Can you get the information from the kiosk or from the net? Because that is very important. Right. That is why it is not. I am not. It is not for me to derive satisfaction that search is not yet placed for 3 years. That is not very convincing for me. Because sometimes appearance may be delayed for one reason or that, either that someone was not served or all these things. But for 3 years, cognizance is not taken. That is bit hard to believe.
Yes, my lord. But
Right. Second half. Okay, now kita likhi daw sorry. T.R. Sharma, petitioner. Okay, UK Goswami already recorded.
Yes,
You are for UK Goswami?
yes, sir.
Okay, 1 and 2. Mr. R.R. Kaushik, learned additional public prosecutor for the respondent number 3. And Miss M. Gordon, I got really get about Namsu Kali. Kali K word and R.R. Kaushik. Find out. So that we can dispose of in a specific term, giving him the liberty to file. Otherwise, there is a judicial order. But since that court has held cognizance, so let me be sure.
yes, my lord. No, that day also we tried, my lord, but we could not get the search sheet in the case record. We'll also try from our end. Lordship is taking up at what?
After some time, somebody keep somebody here.
I'll be there.
Find out.
Item 3.
Yes, Mr. Kolka. And Gupta.
Your lordship may kindly peruse the order dated 21/1/2025, I think. Lordship. At that order, we have been directed
22
22/1/2025,
Huh.
which indicate whether 25 because of land as claimed by the
Uh-huh.
petitioner is missing.
Plus, you were directed
To file an affidavit, lordship.
Ah.
Accordingly, lordship, we had inquired in the, and we have received this letter from the circle office. As because the settlement operation is of 1984 to 2029, during that period. After the settlement operation, I inquired with the circle officer. He told me that after the settlement operation, the earlier records is sent to the DC office as well as the maps are with the director of survey. So this is the instruction we received. So
Whatever,
according
you have to file affidavit.
I am placing this.
No, you file affidavit. Whatever you want to say.
No,
This is a
lordship,
matter where the affidavit is required. It is not a case of.
no, affidavit is required, but by filing that instruction by way of an affidavit will not serve the purpose, lordship. That is why I have to get the instructions from the DC office as well as from the survey office, I
So
think.
how much time you want?
And I inquired, lordship, the DC office is shifting from Hangrabari to Rupnagar, lordship. So the files are,
Tell me what time you require.
lordship, that is the.
Actually, my lord, they have taken sufficient time, my lord, earlier.
Yes, lordship. I don't deny that, lordship.
And
But
my 25 bighas of land, my lord, where gone, I do not know. You have to say, my lord, it.
Somebody responsible has to say something.
yes, lordship. I am just.
Ah.
I have written the letter to the circle officer. That is, it has come, lordship. So, lordship, may I pray?
6 weeks I am granting. 6 weeks.
I will try, lordship. I will try my level best, lordship.
And Mr. P.K. Kolkar, Land Senior Counsel, except by Mr. A. Talukdar, and Counsel for the petition. Petitioners. Revenue. Authorised. H. Sharma. Then additional senior government advocate or authorized 1. Then senior government advocate Assam for the respondent number 2, 3, and 4. Mr. Sharma has submitted that as per the instruction he has received recently, the relevant records pertaining to the land under KP Pata number 154, 155, 156 and 2224 at village number 1 Zaporigo, Moza Beltola. Are not presently available in the office of the respondent of court. Therefore, he needs further time of 6 weeks to obtain instruction from the office of the respondent number 2, which office is being shifted.
Yes, lordship. It is going to be. I have been told that on 15th, but it may postpone also.
Okay. Which office is in the process of shifting?
Lordship.
As sought for sought for by Mr. Sharma. The time period of 6 weeks is allowed. List the case on search.
5th October. 0510.
5.
05.
05. May I get back that?
Yes.
Item 4.
May please your lordship. Lordship, before the petitioner starts, I have a prayer, lordship.
Conducting senior counsel P.J. Shekhya and assisting counsel M. Nirala is out of station, Lordship. Kindly list the matter next week, Lordship.
Not next week, not possible. It is next week.
My lord, I am challenging the action of the respondent, GMDA, my lord. Their presence, they are only a formal party. Otherwise, my lord.
No, if the prayer is made. You have some interim order?
Yes, my lord.
Then okay, Mr. T. Chakraborty. And counsel for the petition. Who is for government? Mr. N. Das, junior government, some for the respondent number 1. Petitioners, huh? Petitioners. Mr. S. Bora, standing counsel GMD for the respondent number 2 and 3. You are for?
Respondent number 5, Lordship. Private
And
respondent.
Mr. Respondent number 4. UK Das, counsel for the respondent number 4 are present. Miss
B.S. Ocha.
B.S. Hoja, learned counsel, appearing for respondent number 5, has submitted that Mr. P.J. Soikia, learned senior counsel, who is leading her in this case, is out of station due to personal reason. Is out of station due to public reason. And so Ms. Oza has thus submitted that the case be listed on another date. Post of the bid made on behalf of respondent 4 is accepted. The request made on behalf of the respondent 4 is accepted as the request is not seriously objected to by the learning counsel for the other parties. So the interim order release the case on so and so. The interim order passed earlier shall continue till the next date of the
2nd September,
Second.
0209.
Obliged, Lordship.
Can it be on a hearing day, if possible?
September দিব লাগিব এতিয়া নহব আগষ্টত নহব আগষ্টত লাইন হৈ আছে
17 September.
7. And be clear of it.
yes yes
That was item number 6, my lord. Next item, my lord.
five
This
five
is
five yes
five.
yes
In this case, my lord, the petitioner number 2 died,
okay
but he has no heir. So his name may be deleted, my lord.
can you file an application through the petition number 1 petition number through the IA through the petition number 1 date certificate just one page statement so that just an IA with a one line statement. Yes, Mr. Alam,
Yeah, I'm from my lord 7 and 8, my lord.
7 and 8. So do you have any interest to file any
Yes, my lord.
reply?
Yes, my lord, I have interest.
Or who needs to file reply? Other respondents? Sharma Das, aforesaid.
2, 3, 4, 5.
Mr. Kolta,
My lord.
anybody's counter affidavit is required? Any official
Actually,
respondents?
if they want to, my lord, because I
I will file.
because
It is against what?
it is against my lord reserve land,
Board of Revenue Order.
Board of
Board of Revenue order, and deletion of my name, my lord, from the patta.
So, any records are required to be called for.
Yes, sir. Record will be necessary, my lord.
So that record has been called for already.
No, my lord.
On notice issue.
Heard Mr. P.K. Koildal, learned senior counsel, stated by Mr. K. Taludar for the petitioners. A. Bhattacharya, standing counsel, Revenue Department for the respondent number 1. Mr. H. Sharma, learned traditional senior government advocate for the respondent number 2, 3, and 4, 2, 3, 4, and 5, and Mr. J. Alam.
G Alam, my lord.
G. Alam, learned counsel for the respondent number
7 and 8.
7 and 8. Post of learned counsel for the parties have submitted that Where is the order? Revenue board order?
Revenue board order, my lord. At page, my lord. 45, my lord.
45.
Yes, my lord. Revenue order, 10. Oh.
Huh?
Prayer portion at page 28, my lord.
No, where is the board of revenue order?
My lord, that is, my lord, there are type copy, my lord, at page 45, down below, my lord, 10/3/1993, my lord.
What, this is of 1993?
93, my lord.
We'll first examine thereafter, will otherwise somebody
Yes,
will be whether this is
Yes.
really called for or required or not.
Required or not,
Now after 30 years.
31 years, my lord.
Okay. Hmm.
Regarding reserve land, my lord. This
Uh-huh.
is the entire case is regarding reserve land. Whether
The official respondents as well as the respondent number 7 in it have not filed any counter affidavit till date. Post of Mr.
G along.
G. Along, Mr. Sharma and Mr. Along have sought for and is granted. How much time you need?
3 weeks, my lord, maybe.
3 weeks time to file their respective counter affidavit. Post of the request is accepted, list the case on so and so. Already there is a direction to file affidavit.
1709.
09.
Then
17
we'll decide,
September.
because 1993 record whether really required to be called for or not.
Obliged.
Timing matter, item 2.
I have checked in this portal, my lord. No update was there. Then I called the GR branch, my lord. From there, I got the information that charge filed, but that has not been laid before the court, my lord, because the petitioner hearing is on bail, my lord. So usually where the bail is granted, in those cases, my lord, they somehow used to place lately, my lord.
Okay.
My lord.
Anyway, a judicial order is there declining your application. Yes. So that prevents the court to exercise power under 226, only 528, because that court can set aside that order. Also, will give me that liberty to approach under 528. Right, and we'll refer to the gazette notifications. Yes. Which permits that court, because that court has observed that that court has no power. So that is why we'll refer to those notifications so that it will be a self-contained order so that you can seek.
Daily list, item 6.
That two items is under the impression that this order was going to be passed. Item number 2. So I'm a senior window under board document after some time.
Yes, Mr. Choudhury, you were here.
For hearing, item 7.
6 timing.
Please, Lordship. At the outset, Your Lordship, I pray for adjournment. As Your Honor, yesterday we came to know that one of the appellant has expired, Your Lordship.
One of the,
Appellants has expired.
let us see what is your case first. Because
So,
there is a direction, no adjournment is to be granted.
no, Lordship, we have to take an appropriate steps to take to file the necessary application for substitution, Lordship.
Who expired?
Lordship. The appellant 12D, Srimati Suman Devi Jain, Lordship.
Suman Devi Jain.
Jain, yes,
We
Lordship.
see,
She is one of the co-appellants, Lordship.
we see with the, what is her relation with the deceased?
She was the sister of the deceased, Your Lordship.
Our sister, but
She is not
deceased?
the dependent one, Lordship.
No, who is her? She is married or unmarried?
She is married, Lordship.
Then husband will not be dependent.
Yes, no, that's her brother has expired, Lordship.
If she is married,
Yes, Lordship.
her legal representatives will not be dependent upon the deceased.
Yeah, I know, Lordship.
Let us see. What is the ground of appeal?
Lordship, I'm
You
not
are for respondent.
not appellant, Lordship.
Appellant Sanjay Jain.
Yes, Lord.
Just a minute. Please take your seat. Let me see. This appeal is for what?
For enhancement, Lordship.
Enhancement.
Yes, Lordship.
On what ground?
On Your Lordship, the ground is mentioned in paragraph number 4 and sorry, Lordship, page
4.
number 4, Lordship. Page number 4, paragraph number 4 and 5, Lordship.
4
Up
and
to
5.
8.
Four is very vague. Has committed manifest error.
Lordship, the deceased was the he was an astronaut, Lordship.
Hmm?
He's studying astronaut studying, and he has a bright future, Lordship.
Astronaut working in Janata food grain store.
No, Lordship, he's
Huh?
no, Lordship. He studied aeronautical engineer. I apologize. He's studying aeronautical engineer, Lordship.
But working in Janata food grain store.
Is his part-time doing so?
When you are going to file?
Within the next week, Lordship.
You are for?
Lordship, I'm appearing for respondent number 2, one of the insurance company, Your Lordship.
Hard miss?
PCB Nair, Lordship.
PCB Nair.
Yes, Lordship.
Learned counsel for the appellants. And Miss?
P. Botthapur.
For which one?
Respondent number 2, Your Lordship, New India Assurance Company
Learned
Limited.
counsel for the respondent number 2. Post of Miss Nair has submitted that during the pendency of the appeal, one of the appellants, that is appellant number 1 within brackets small d, has expired, and therefore the appellants need to file an application for substitution when she expired.
Lordship. On 20th February 2026, but we came to know yesterday, Lordship.
20th February 2026. And therefore, the appellants need to file an appropriate needs to file appropriate pleadings for substitution. Post of Ms. Nair has therefore sought for a week's time to file appropriate pleading for pleadings for substitution. Considering the ground cited, the request for adjournment of case by 1 week is accepted. This is the case. After we connect it to expired hours.
That's all.
This is the appeal.
Items 8 to 14.
I have inquired myself why these MSc appeals are listed before this court. And there is a direction from the Supreme Court.
I understand. Old
So,
matters.
All matters,
Yes.
they said that no MSc appeal above 4 years should be left undecided. And this appeal is 12 years. Next, after 15 days, again, there will be inquiry from Supreme Court. And if it is reported that this court was given the task to decide the appeal and it has adjourned, that will be in bad light.
We understand.
Right?
We understand.
So that is why I insisted it is, will at least start,
Yes, ma'am.
right? If
But,
really some
yes,
emergent issue appears, then we'll see.
My learned friend, in fact, he informed me yesterday that.
No, if really there is a very complex question of law is involved, then we'll think about it. But let us start.
Yes.
Yes.
It is basically on a judgment.
Well,
On a judgment of the MSCT court.
on the
Tribunal.
Well,
Yes.
but what had happened, Malad, there are altogether 7 cases filed.
7.
7 claim cases filed.
Right. Yes.
Three are for the, by the dependents of.
Let us see from the cause list.
Milo.
Item number 8. This is a date.
Item number 8
Have you
is.
prepared any chart?
Yes, my lord. I have.
Have you prepared any
Yes,
chart
Yes, my.
for the assistance of the court?
Yes, my.
Because
It's only handwritten, my lord.
okay. Do you have extra copy with you yourself or not?
No, I have done my noting.
Which are death cases?
Death cases are Lakshmi Gupta,
Just a
Ranu
minute.
Dole.
Just no, by serial number in the cause list.
Yes, ma'am. Item number 14.
Okay, let us proceed with the tribunal judgment.
I just point out item number 14, item number 10.
14.
10.
10.
And
10,
and
14.
12. 10, 12 and 14 are death cases.
Any injury case?
Injury cases are, my lord, 8,
8.
9,
9.
13,
13.
my lord. And my lord, damage to the property is again 8.
8.
There are injuries also. There are damage to the
property
property also.
8.
8, 11, and
Damage to property.
8, 9, and 11.
8, 9, and 11. Common judgment?
Common judgment.
Okay. One vehicle or
2 vehicles, my lord.
2 vehicles?
We are for the truck. We are insurer of the truck.
So, national insurance is
Insurer
Truck.
of the truck.
national insurance
Truck.
truck insurer. And what is the other vehicle involved?
Other vehicle involved is a
Scooter, my lord.
which was insured with New India Assurance Company.
If I'm paying for the other insurance company.
New India.
I am appearing for the owner of the scooter.
Okay, just a minute. R.K. Patra. And P. Dotto.
M. Dotto, my lord.
Or M. Dotto. M. Dotto for owner of scooter. And Miss
He bought the food.
P. Botthakuru, insurer.
So not your insurer of this.
Okay, where are the claimants? All are served.
All are
All
served,
are
my
served.
lord, they did not appear.
Did not appear. Okay. Now, how liability is fixed?
My lord, we had issued a cover note,
No. How liability is fixed?
80:20, my lord. The truck is
80 is to
20,
20.
my lord. Truck is
And 80 to national insurance.
yes, ma'am. And 20 on
20.
the owner of the scooty because there was no coverage to the scooty. my lord.
20
You
is
have
upon
not
me.
appealed.
My lord.
You have not appealed.
My
He
lord,
has not
I
appealed.
am not prepared in appeal. That
So
is
that
my,
remains.
That remains, my lord.
so I'm my, so I am
We
totally
cannot go
rely on
into that.
order 41 rule.
In the absence of any, no, order 41, rule 22, you have to file a cross objection.
No, my lord.
Have you filed?
No, order 41, order 41 rule 33, my lord.
Or rule 33,
Power
why
of
should we
court of
decide
appeal,
that?
my lord.
There
No,
are
no,
other
that is
decisions.
there, my lord. My submission will
Order
be
41,
confined on
rule
that.
33, why should I decide?
No, my lord, my submission is that, my lord. The 20% which was given upon me, my lord, that was a perverse finding, my lord. And I admit, my lord, I am not
No,
preferred.
so some authority that just because that provision is there in such a case, in the absence of appeal, or
Yes.
that 41-23,
My lord, problem is that, my lord, I am, my
what
lord,
is the authority of law?
my lord, I will place, my lord. But the problem is that, my lord, I have missed my lord, some, my file, my lord. That is my difficulty. So I
Yes,
requested,
So, my lord, the case of the claimant was, my lord, should I start with the?
Yes, let us read the judgment, that is
Yes,
all.
fine.
That will decide.
That will suffice. my lord.
Huh.
I read from page 8, my lord, the judgment.
जाओ complete.
Paragraph 2.
Read from 1.
My lord, the above seven analogous cases have arisen out of the same accident and against the same opposite parties. As such, I am proposed to dispose of the same by common judgment. In MSC case number so and so, the claimant Sarda Gupta filed this application under section 166 of MV Act, seeking compensation of rupees 7,20,120 on account of death of her daughter, Srimati Lakshmi Gupta, in a motor vehicle accident. In MSC case number 162/2003, the claimant Sri Lakshinath Doloy filed application under section 166 of MV Act, seeking compensation of rupees 11,28,072 on account of death of his sister Srimati Ranu Doloy in the aforesaid accident. In MSC case number 163/2003, the claimant Srimati Akomani Das filed petitions under section so and so, seeking compensation of rupees 9,94,000 on account of death of her husband Sri Kulomon Das. Similar petitions was filed by the claimant Ramananda Das, seeking compensation of rupees 6,75,000 on account of injuries sustained by him by MSC case number 227 of 2004. In MSC case number 244 of 2004, the claimant Sri Mohan Sekia has filed application under section 166 of MV Act, seeking adequate compensation of rupees 2,35,000 on account of injuries sustained by his minor son Ramtumoni Sekia and damage to his property. In MSC case number 256/2004, the claimant Sri Kamal Sri Kamal Health.
Page 3 is missing here. Page 1. Page 2. Page 3 is missing. Just a minute. Normally. You have page 3.
My lord.
Huh?
Yes, ma'am. I'm giving a set of.
File is any song? Okay. Okay. It is better.
Page 3, my lord.
Oh, both sides. Both sides. Just a It's not there. Just a minute, huh? My super. Talking about the page number 3,009. Judgment to page number 3,007.
Kamal
Hmm.
Iloidhari filed petition under section 166 seeking compensation to the tune of rupees 1,90,000 on account of damage to his properties due to the accident. And the claimant Sri Sanjeev Iloidhari filed application under section so and so claiming compensation of rupees 2 lakh for injuries sustained in the motor vehicle accident, white case number 257 of 2004. The facts giving rise to the above proceedings may be stated as under that on 9/5/2003 at about 8:40 a.m. Srimati Lakshmi Gupta, Srimati Ranu Doloy, Sri Kulaman Das, Sri Ramananda Das and Sri Sanjeev Heldiyari were waiting for bus at Rangagora Tinali on National Highway 37. Meanwhile, one truck bearing registration number AS044271 came from Dergaon side towards Bokakhat town along the NH 37, driven in rash and negligent manner. One LML scooter bearing registration number so and so was moving ahead of the said truck, driven rashly and negligently in a zigzag manner, and not making any room for the truck to overtake it. While both the scooter and the truck reached Rangagora Tiniali, the scooter abruptly turned to the right side without giving any signal to the following truck. In the process of saving the scooter, the truck could not control its speed and knocked down the standing passengers waiting for the bus at Rangagora Tinali. Sri Kulomon Das received serious injuries and died on the spot, while Sri Ramananda Das, Sri Sanjay,
No. As the result, Sri Lakshmi Gupta,
my lord.
as a result,
As a result, Sri Lakshmi Gupta, Sri Ranu Doloy, Sri Kulamon Das received serious injuries and died on the spot. While Sri Ramananda Das, Sri Sanjeev Holidiyari and Sri Rontumoni Soikia, minor son of the claimant Sri Mohan Soikia, sustained injuries on their person. In the alleged accident, 3 Pan Gumti belonging to the claimant Sri Mohan Soikia, Sri Kamal Hiloidhari, situated at Rangagora Tiniali were damaged along with stock and provisions therein. Hence the prayer for compensation by the claimants in their respective cases. Notices were served on all the opposite party except the opposite party number 6 as shown in the MSC case number so and so. All other opposite party contested the claim by submitting written statements separately. The OP number 1 is the owner of the offending vehicle number so and so, that is truck, my lord. In his written statement, it is stated that there is no cause of action for the claim petition and the claim petition is not maintainable in the eyes of law. That there was no rashness and negligence on the part of driver of the vehicle number so and so truck, and the alleged accident took place due to negligence and rashness of the LML scooter bearing registration number so and so driven by its owner Sri Migam Chandra Mehta. It is stated that the vehicle number so and so truck is duly insured with the opposite party National Insurance Company Jorhat branch, and hence the prayer to relieve him from the liability of the case. The opposite party National Insurance Company Limited has stated in their written statement that policy number so and so issued by it in favor of the owner of the truck does not cover the date of accident, as the same is valid from 12/5/2003 to 11/5/2004. Whereas the alleged accident took place on 9/5/2003 and the policy was obtained by suppressing the material facts. According to it, the alleged accident took place due to rash and negligent driving of the driver of LML scooter number so and so. That its appointed investigator is yet to submit report about the genuineness of the DL of the vehicle truck, that the amount claimed is very excessive and without any basis, hence the prayer to dismiss the claim petition. The opposite party, New India Assurance Company Limited, has stated in their written statement that there is no cause of action to file the claim petition against them, as the vehicle in question, that is LML scooter bearing number so and so, is not under their valid insurance coverage at the relevant time, and the claimants wrongly added the OP as party in the claim petition and hence the prayer to dismiss the claim against them. Opposite party Sri Megan Chandra Medak is the owner of the LML scooter number so and so. In his written statement, he has denied involvement of his LML scooter in the alleged accident. Rather, he has contended that he, being a government employee, used to attend office at Jorhat by making to and fro journey by bus, and he is falsely implicated in Kumargaon PS case number so and so. Hence, he prays to relieve him from the liability of the case. Upon the pleadings of the parties, the following issues are framed for determination. Number one, my lord, whether the accident took place due to rash and negligent driving of vehicle number so and so truck and so and so LML scooter, and whether the above vehicles were under due insurance coverage at the relevant time. Whether the claimants are entitled to get compensation in respect of their cases, if so, to what extent and from whom. The claimants examined themselves as sole witnesses in respect of their cases claimed and admitted into evidence necessary documents. The opposite party also examined 3 witnesses and exhibited necessary documents. I have heard argument of both sides and perused the evidence on record. Also perused the written argument submitted by National Insurance Company. Now the issue number 1 is taken up. CW1, Sri Lakshinath Doloy, the claimant in MSC case number so and so, has stated in his affidavit under orders 18 rule 4 CPC that his sister Ranu Doloy was standing at the extreme left side of the national highway near Rongagora Tineyali under Kumargaon police station on 9/5/2003 at about 8:40 AM in order to board a bus to go to her workplace. At that time, one truck bearing registration number so and so came from Dergaon side towards Bukaka, driven rashly and negligently along the national highway, and LML scooter bearing registration number so and so was also coming ahead of the truck, driven in rash and negligent manner in zigzag way, and did not allow the truck to overtake it. Near Rongagora Tiniali, the LML scooter suddenly turned towards right side without giving any signal to the following truck, and in the process of saving the scooter, the truck steered towards left and dashed the roadside waiting passengers, killing 3 of them on the spot and injuring 3 others, beside damaging 3 gumti, including stocks and provisions therein. CW1 Lakkikant Doloy has stated that his sister Ranu Doloy sustained severe injuries, serious injury, and died on the spot. According to him, the accident occurred due to rash and negligent driving of truck bearing registration number so and so and LML scooter bearing registration number so and so. So, the rash and negligence was alleged against both the vehicles. that a criminal case number so and so was under section so and so was registered against the drivers of both the aforesaid vehicles. It is also stated that both the offending vehicles were duly and adequately insured at the relevant time. From the evidence of other claimants, it is found that they have supported each other in respect of the accident as to how and under what circumstances it occurred, and thereby causing death of 3 persons and injuries to 3 others, apart from damaging 3 gumti, along with stock and provisions. It is also found from the materials on record that as a result of accident, Srimati Lakshmi Gupta, Srimati Ranu Dolai, and Sri Kulamon Das sustained serious injuries on their person and died on the spot, while Sri Ramananda Das, Sri Sanjeev Hiloidhari, and Sri Rantumoni Soikia sustained injuries on their person. In the aforesaid accident, Sri Pan Gumti belonging to claimant Sri Mohan Soikia and Sri Kamal Hiloidhari, situated at Rangagora, Tiniali, were damaged along with its stock and provisions. The claimants were cross-examined by the office, but nothing could be elicited in their favor. CW1 Lokinath Doloy has stated in his cross-examination that he has not seen the alleged accident, but denied the fact that the LML scooter was not plied in a zigzag way. According to him, the alleged accident occurred at a distance of about 1 furlong from his home. So he might have gathered knowledge about it from people present at the time of occurrence. The opposite party, Sri Migen Chandra Medak, examined himself as witness number 1 in support of his contention raised in his written statement. He stated in his affidavit under Order 18 Rule 4 CPC that he was not driving the scooter number so and so in a zigzag way, and also in rash and negligent manner from Delgaon side towards Bokakhat on relevant date of it. Whereas in the written statement, he has stated that he used to board a bus and go to his workplace. Now, in his own evidence, he has stated that he had not driven the scooter in zigzag manner. Rather, he attended his office by boarding bus at Rangagora Tiniali towards Jorat as usual, and as such, there was no occasion on his part to ride the LML scooter in question. He has denied the involvement of vehicle number so and so in the alleged accident. In his cross-examination, he admitted registration of a criminal case by the police against him, showing involvement of his vehicle in the alleged accident. He has further denied that his vehicle and had no insurance coverage at the relevant time, and as such, he has deposed falsely. The claimants have exhibited the accident report by Exhibit 1 in their respective cases and the certified copy of FIR by Exhibit 2. From Exhibit 1, it is found that the vehicle number so and so truck and the number so and so are involved in the alleged accident that took place on 9/5/2003 at about 9 a.m. at Rangagora Tiniali on NH 37. And at the relevant time, the above vehicles were driven by Sri Hema Chauhan and Sri Migam Chandra Medak. Exhibit 2 also supported the contents of Exhibit 1. From the copy of FIR lodged by the officer in charge of Kumargaon PS in reference to Kumargaon PS GT number 190 dated 9/5/2003, it is seen that the alleged accident took place at Rangagora Tiniali on 9/5/2003 at about 8:40 a.m. involving the vehicle number so and so and one motorcyclist, namely Migam Chandra Medak. And the accident occurred due to rash and negligent driving of both the vehicles. It is also found that as a result of the aforesaid accident, Srimati Ranu Dole, Srimati Lakshmi Gupta, and Sri Kulamon Das sustained serious injuries on their person and died on the spot. 3 other persons also received injuries on their person besides damaging 3 Pangumti. From the certified copy of the charge sheet, it is found that both the drivers, Sri Hemo Chauhan and Sri Migam Chandra Medak, were charge sheeted by charge sheet number 12 of 2004 dated 27/2/2004. From the certified copy of seizure list in reference to Kumargaon PS case number so and so, it is found that the investigating officer in course of inquiry seized the vehicle number AS06B6286. This is the LML scooter belonging to Sri Migam Chandra Medak along with his document. So the seizure of vehicle number so and so and submission of charge sheet against both the drivers of the offending vehicle goes to show that the alleged accident took place due to rash and negligent driving on the part of drivers of both the vehicles. So the plea taken by the OP Sri Migam Chandra Medak that on relevant date he was attending his office at Jorhat by boarding bus cannot be accepted without cogent and impeachable evidence. From the evidence of the claimants supported by Exhibit 1, 2 and certified copy of charge sheet and seizure of offending vehicle, it is established that the alleged accident occurred due to rash and negligent driving of both the vehicles number so and so, truck and scooter, causing death to so and injuries to 3 others. Now the question is whether the above 2 offending vehicles were under insurance coverage at the relevant time of accident. So, my lord, the finding with regard to rash and negligence was against both the drivers. The OP New India Insurance Company Limited has denied insurance coverage in respect of offending vehicle number so and so LML scooter with them. The OP Sri Migam Chandra Medak has submitted in cross-examination in MSC case number 163 of 2003 that there was no insurance coverage of his scooter at the time of accident. He himself has admitted in one of the
So,
analogous
Mr.
cases.
Rao, whether this is correct or not?
Lordship, this is
Correct
correct
or
my lord.
not?
This is correct, my lord. I don't have insurance, my lord, at that relevant time. my lord.
So it is there in the testimony.
Yes, yes.
In MSC case number 163 of 2003. So hence the opposite party, New India Insurance Company Limited, is relieved from the liability of case and same will go against the OP Sri Migam Chandran Medak, the owner of the offending vehicle, LML scooter. The learned advocate Mr. P. Singh, appearing on behalf of the opposite party, National Insurance Company Limited, has argued that the vehicle bearing number so and so truck was not insured at the time of accident. According to him, the alleged accident occurred on 9/5/2003 at about 8:40 a.m. and the cover note number 080220 is issued on 9/5/2003 at about 6 p.m. in the evening. Thus, the cover note is obtained by suppressing the facts of the accident. As such, the opposite party, National Insurance Company Limited, is not liable to pay compensation to the claimants. In support of the above submissions, the opposite party, National Insurance, has examined Sri Nirmal Kumar Das as DW2 and another Sri Apurva Kumar Fukan as DW3. Both DW2 and 3 exhibited the cover note number so and so as Exhibit A and Exhibit 1. In their evidence through affidavit, they admitted issuance of cover note in question in respect of vehicle number so and so truck, showing date of commencement of the said cover note from 6 p.m. onwards on 9/5/2003. The alleged accident occurred on 9/5/2003 at 8:40 a.m. and thus the cover note is obtained by fraud suppressing the facts of accident. In cross-examination, DW2 stated that their official timing is from 10:30 a.m. to 5:30 and the transaction with with public is up to 4 p.m. and they came to know about the accident within 2-3 days of issuance of cover note. DW2 also admitted that they collected premium at 6 p.m. DW3 also admitted in cross-examination that he has issued the cover note in question in the field. DW2 stated that they came to know about the accident within 2-3 days of issuance of the cover note. When DW2 and 3 came to know about the fraud committed by the owner of the offending vehicle truck by suppressing the fact of the accident, then it was the duty on their part to cancel the cover note. But they did not do so. In this connection, the learned counsel for the claimants has referred to case law reported in so and so of the Honorable Supreme Court in the case of Oriental Insurance Company Limited versus Dharamchand and others. The observation is quoted here. May I read, Malad?
Yes, yes.
Motor Vehicle Act number 1988, Section 147 and Insurance Act 1938, Section 64 VB. Motor insurance policy commencement of liability of insurance company. Premium check was received by insurance company at 4 p.m. on 7/5/1998 and cover note issued in which it was mentioned that insurance would commence from 8/5/1998 and expire on 7/5/1998. Vehicle met with an accident at 8:30 p.m. on 7/5/1998. Insurance company seeks to disown its liability on the ground that accident took place before commencement of the insurance. Tribunal and High Court held insurance company liable. Whether the insurance must be deemed to have commenced from the time check was received, and insurance company is held liable. The Supreme Court said yes. Another case referred by learned counsel for the claimant is 2001 2 GLT 34 in the case of National Insurance Company Limited versus Ashoka Das and others. The relevant portion is as under. The Motor Vehicle Act compensation disease expired on 17/12/1992 at 5:30 a.m. due to motor accident. Vehicle got insured on 17/12/92 during office hours. Plea raised by the insurance company that on 17/12/92 at 5:30 a.m. the vehicle was not insured with it, and thus the company is not liable for compensation. Insurance of the vehicle commenced from 17/12/92. Such commencement is from preceding midnight of 0 hours, intervening 16/12/92 and 17/12/92. Rejecting the plea of suppression of accident by the vehicle owner, held insurance company is liable to pay the compensation. The vehicle covered by the insurance policy, more particularly when the insurance company did not repudiate the contract on detection of alleged suppression. So both the cases were in favor of the claimant. The second ruling of our Honorable High Court is very much applicable under the facts and circumstances of the case. So the OP National Insurance Company cannot escape from the liability of the cases in our hand, being the insurer of the offending vehicle number of truck. The issue number 1 is accordingly decided accordingly. Issue number 2, my lord. From my finding and decision in this foregoing issue, it is crystal clear that the claimants are entitled to get compensation from the OP Sri Nigam Chandra Medak, the owner of scooter, and OP National Insurance Company Limited, being the insurer of the truck. Now let me decide the quantum of compensation in each case separately.
So you are not into quantum.
We are not into quantum.
You are into issue number 1.
Right.
That since the cover note was issued at 6 or 6:30 p.m.
6 p.m.
on the date of the accident, and the accident occurred at 8:30 or 8:40 a.m.
Mile.
So by such issuance of cover note, the accident is not covered. So at the time of the accident, there was no insurance coverage. That is your case.
Mile. And the policy was also executed.
And then other since the appellant claimants have not, if you are correct,
Mile.
if on this point is this appeal is allowed,
Mile.
you are exonerated of the liability to pay, or any question of this pay and recover comes in.
Recovery does not come, my lord. There's a full bench decision also I have come across. It says that if cover notes are issued, but only thing will be, my lord, whether the
Have you paid? Have you paid?
This amounts I think, my lord, before the tribunal all the amounts are paid. I'm not very sure about it. I'll find out. But question remains, my lord, whether the insurance company has taken a stand of cancelling the policy after they have come.
The question is first whether you are liable or not.
Right. So, my lord, I give a copy of the policy also, which was exhibited.
Where are those? In the record?
I'll try to.
In which record it is available?
I'll just try.
In which record?
In Mohan Sikhi's case, my lord.
Wait. Exhibit A and Exhibit B.
Exhibit A and B. Page 23 and 24 of the
Yes, file. TCL.
Yeah. This was then, my lord, I don't have any other things to urge, my lord. Otherwise, my lord, the
Now, what is the,
damaged,
because
damaged.
Mr. Bhatra, I have not taken up any MSc bill for last 5, 6 years. Now, what is the development of law with regard to pay and recovery? Because there are many other conflicting judgments.
Yes, your logic
So,
is correct.
on this point, what is the law presently?
I'll try to cite. In fact, my lord, I also could not prepare thinking that my learned friend will seek enthronement. So otherwise, my lord, I have brought a copy of my lord, a full bench decision.
Just a minute, we will see our finding.
113.
In which case, this scooter owner had said
163, my lord. That is
163, MSc 163.
no. But this MSc is the number 163. And
M- 163.
MSc will be
163.
162.
No, 163. Take it up. It will cover tomorrow.
Item number 12, my lord.
It will know.
The owner, my lord, statement of owner.
One
3,000.
163. It will.
162.
This is that. Huh?
162.
You might take it with you, but you make it with you. Got the cover note.
My lord.
Recovered the cover note. Now you said 163. It will very fine. Adira. Sir, 163 is perfect. We find our position file. Exhibit file. Our topic is what? Just judgment process.
My lord, may see MSc case number 16203.
16203.
03. And my lord, in that, my lord, I have not, my lord, admitted that, my lord, I don't have any insurance policy, my lord. In cross, my lord, I have said there was insurance coverage of my
No,
scooty.
cases of the case where you said so is 163 according to the trial court.
Yes.
So we are looking into that.
Item number 12.
Why we'll look at the others?
Item number 12. Only Das. 160. MSc appeal will be 224 of 2012. য'ত লিংক পিটিশ্যনখন আছে ন তাতে আছে এইটো হ'ব পাৰে এই তলত তলত এই তলত এইটো নহয় তাৰ তলত এইটো কি হয় আন্দাজ ঠিকে আছে I could guess correctly. 160. Somebody has marked it, that is why it might be that.
Yes. This was in fact taken up many times, but.
My lord, today, my lord, I have, as because, my lord, I have gone through the, my lord.
Okay.
Because, my lord,
Okay.
my file has been misplaced, my lord. Therefore, my lord, I have checked the record and whatever I have collected, so that.
The tribunal says during the cross-examination, my lord.
Looking at it. Loud and clear.
My lord.
There was no insurance coverage of my scooter at the time of accident. Loud and clear.
My lord, in MSc,
MSc, that
163.
If you want to satisfy yourself.
Well, in MSc 162, my lord.
No, whatever.
Yes.
It is there. You want to see with your own eyes.
No, my lord.
Please have a look. Because I have looked at the name of the presiding judge, Justice Lohar. He is very meticulous.
Very, very pertinent.
I have had the experience.
My lord, he was very.
Of arguing matter before him. He is
Yes.
so meticulous.
Very meticulous.
That is there. But my lord, 162 says, my lord, different.
Additional CGM here.
Correct.
So after last year, I met him in Tezpur. Mongol. He now stays in Mongol.
But in 162, my lord, that no word is not there.
Whatever. You cannot.
Moreover, my lord, when the cover note was issued, the policy was issued on 12th. Because Saturday, Sunday was intervening. The policy was issued on 12th.
This is a policy I have seen.
Yes, my lord.
It is specific that 8/5/2024.
Fine.
It was exhibited.
Well, 6 PM also, timing is also there.
Exhibit A. Taco is here? No.
No.
Exhibit A and exhibit B to like you, huh? So it will Exhibit A and exhibit 1. Okay. Yes, now on the law, point of law.
So, my lord, my submission would be, my lord, the cover was not there at the time of accident. And
Any authority?
My lord, yeah, I have provided one.
Which one?
Defense decision, my lord. Rakesh Talwar, my lord. 2009 SCC 229.
Motor vehicle expansion.
There is another case, my lord.
Just a minute, just a minute, just a minute.
Yes, sir.
Yes.
Talwar. Citation to give her. 2009 SCC 229.
Insurance being liability.
2009 SCC. 9 volume 9.
This owner contested in the
Tribunal, my lord.
tribunal.
He had filed a written statement, my lord.
He said I had insurance.
Yes. There are two more decisions, my lord, which I would like to rely, my lord.
Sure, sure.
But in those cases, my lord, the Supreme Court has held that since you have paid the amount, you not pick up. All are related to the issuance of cover note and time of accident. All three. Ramesh Talwar will be para 7, my lord. Finding it as 7, but para 5 onwards, my lord. Ramesh Talwar. I have also relied on Sunita Rathi, my lord, which I have.
Yes. One more.
This Gita Devi is again, my lord, has distinguished Ramdayal.
This also, this Sunita also.
My Sunita Devi has been, my lord, relied on by the full bench also, has been
Full, where is the full bench?
2009 SCC 229, my lord, Rakesh Talwar.
It is three bench.
Three judges.
Sunita Rathi is also three bench.
I overlooked, man. I
Yes, three
overlooked, man. Yes,
judgments.
I overlooked. In fact, in Rakesh Talwar, the court has held that whatever amount was paid, directed the owner to pay it back to the insurance.
Rakesh.
Yes, ma'am. Paragraph 7. Ma'am. While allowing the appeal and set aside the impugned judgment, we directed.
Now, did you pay?
That, my lord, I have to find out, my lord. Because normally, when this question of policy is there, my lord, the payments are not made. I have to find out.
Any interim order?
No, no interim order. We did not press for the interim order because no liability was there, so we did not press for that. There was no order passed in the IA. All the appeals, my lord, stay was granted without directing us to make any payment.
No stay.
The stay was there.
Oh, stay was there?
Yes, ma'am. If I'm not wrong, my lord, there was an order.
Show us an order.
On 2/5/2023, my lord. 2013.
Show us that.
I 1062 2013. This is an item number 1. Eight. Item number 8, 1062 of 2013.
Order 41 Rule 33 will not be applicable in view of your categorical admission.
My lord, that is there, but my lord, whether
And finding of fact, unless we find that it is not perverse, because firstly, there is a 5-bench judgment on Supreme Court once or something that one in the charge sheet, you were arraigned as an accused. Though for the criminal trial, it is a different matter altogether as the standard.
Correct.
But here in a case, it will be assumed. There are many decisions.
Many decisions that I could not
That
prepare.
is one. Secondly, this categorical finding of fact by the tribunal. Fourth, no insurance. It is an eyewitness account of all the claimants, surviving claimants, that two things are involved, two vehicles. So we need not labor on that.
But
Order 41 Rule 23 does not apply.
my lord, my respectful submission is that, my lord, the scooter, my lord, did not contributed to the, my lord, accident, my lord. Because, my lord, here in this case, what I have found, my lord,
In view of, if you want to contest, then show us the claimants, the eyewitness, injured testimonies. Just because one statement by you, by entering into the witness box, show us the testimony
my
of
lord,
all the eyewitness, injured eyewitnesses, how they had deposed.
Yes.
Show us from the testimony, because you are seeking an invocation of an extraordinary power. It is not under Order 41, Rule 22. It is under Order 41, Rule 33.
Yes.
If the court finds that is purely the discretion of the court on the basis of the facts or laid in evidence, this is purely and purely discretionary. And you self admitted.
And my lord, why I am saying
And
so? My lord,
Mr. Now show us, right? That is why I asked you, show up from the testimony of the surviving injured persons, their testimony.
my lord, if
So,
your lordship allow me to.
No, I have
My
not
lord,
seen
my-
also.
Yes.
I have not seen, I have not come, I have not looked into the record.
My
So
lord,
you are a seasoned counsel, you can look into the record and help the court.
yes, my lord, I will go through, my lord. I will.
Go through it right now. My memory is very limited.
All the claim petition.
12 hours it will remain.
My lord, our stand is that, my lord, at that relevant point of time, my lord, I was at my office, man. And there was no question of riding that motor scooter at that particular time. That is our stand, my lord. And I have, our stand is that, my lord, we have never contributed to the accident.
First item number 8 to the LCA.
And in the FIR also, my lord, there is no mention of, my lord, this, my lord, zigzag. We have driven, the scooter was driving in zigzag manner. My lord, I have gone through the FIR, my lord, exhibit 2. My lord.
That is
My lord,
only.
that was, my lord,
That
after
cannot be.
inquiry, my lord.
But what about search sheet?
Search sheet was, my lord, not exhibited, my lord. Search sheet was not exhibited, my lord.
Court has
Only the FIR and the accident information report. In many cases, my lord, no specific.
That will not
And-
hold water.
And my lord,
before this court.
and my lord, in many
In
cases,
the
my lord,
absence of any appeal, we will not look
my
into
lord,
any submission.
what had happened, my lord? The tribunal has, my lord,
Mr. Dutta come with an authority under Order 41, Rule 23. In this kind of situation, whether Order 41, Rule 23 can be invoked. I think at one point of time, I have also looked into Order 41, Rule 23. I don't think that it is possible to be invoked.
my lord,
Provision is there.
my lord may grant me some time. So I
No,
will satisfy and I will
continue with the
yes.
dictation.
My lord may keep it at part heard, my lord.
No, we'll not keep it part of. We'll continue with the dictation. If by 4:30 it does not end, you will get the opportunity.
My lord may
No
kindly see the exhibit 2, my lord, the FIR, my lord. What it says, my lord.
Exhibit 2 is not the final thing. It is not an encyclopedia. Yesterday also, Supreme Court has said it is not to be looked into.
And even, my lord, in
Question
many,
is, what is the testimony? Mr. Doctor, let us see the testimony of the witness. That is why I am looking at it. No point.
my lord, I am just reading that part of the.
Starda Gupta. Who was then injured? Give me a case of injured one.
My lord.
Let me ignore.
Injured are, my lord, Rontumoni Soikia. That is item number 5. Sorry, my lord.
Item number 8, 9, 13.
8, 9, 13, my lord.
8.
8,
Item?
9, and 13.
First, one by one.
8 is injured.
LCR of 8. Okay, exhibit. 8 Mohan Shakir.
I have given a handwritten chart, my lord, that will verify.
মহেন শইকীয়াটো আছে নেকি?
Mohan Singh.
মহেন শইকীয়া কোনটো? এইটো লক্ষ্মী বাই নে কিবা? এইটো নেকি? এইটো চাওঁ। So, Akomani is injured or diseased?
Death, my lord, Akumani Das.
Oh. শইকীয়া ভক্তত আহিছে নেকি এখন? Did you enter into witness box anywhere?
Yes, my lord. Yes,
In which case?
my lord, 162, my lord, MSC case number 16203.
What is the case set up there?
My lord,
You simply said that you are not driving.
He said that I was
Not driving the motorcycle at the relevant point of time. Right?
yes, my lord.
That is what you said.
And my
At
lord,
the same time, you said not involved.
because
But
I,
at the
at that
same time, you admitted that your motorcycle was seized. Then you also admitted somewhere you have no insurance. Motorcycle was seized.
163, he admitted.
And motorcycle was seized. He admitted in this case. Then you were charge sheeted. But even if you were acquitted or discharged, that will not help in this case. And they said the motorcycle was involved. Then you should have, you simply said motorcycle was not involved. It is not your case that somebody else was driving. Even if somebody else was driving, you would be liable.
That type of nothing is there.
That was not there. And but most importantly, in 7 cases, you were held 20% liable.
My lord, what had happened, my lord? In 7 cases, it was taken up together for, my lord, disposal, and same, my lord, what the, my lord, may kindly see the, my lord, the operative part of the order, my lord, of the tribunal. My lord. There says, my lord, the claims are awarded on contest.
While OP Migom Sondro Meadow shall pay the balance 20% of the awarded amount to the claimants in all the above same cases on the principle of heavier the vehicle, heavier is the responsibility.
Yes, my lord.
Within so and so. It is loud and clear. Right. And I have found out that Migom Sondro Meadow is not an illiterate person.
He's not an illiterate. He was an
He is
at
an
that time he was an
assistant
executive
engineer
Yes.
in the irrigation department.
Yes. That is there. But here,
That it is not cannot be said that he has not understood the English.
my lord, my lord, the operative person says, my lord, shall pay 80% of the, in other words, OP number 3, the National Insurance Company Limited shall pay 80% of the award amount to the claimants in their respective cases, while OP number 4, Migom Sondro Meadow shall pay the balance 20% of the awarded amount to the claimants in all the above 7 cases on the principle of heavier is the vehicle, heavier is the responsibility within 60 days. So, my lord, but the tribunal has not come to a finding that he was negligent, my lord. He was also negligent. To that effect, my lord, there was no finding as such, my lord. And even, my lord, in many cases, my lord, there was not a single allegation against this, my lord, the scooter, my lord. If your lordship see the,
What is that called? What is that term called? Composite liability or what? What is that?
It will be a composite liability for the third party.
That is a term, right?
Yeah.
And apportionment is also the
Right.
same principle.
Right.
on money to apna injury take place.
Only death case.
Your plea was considered. And the plea taken by the OP, Sri Migom Sondro Meadow,
Yes.
that on the relevant date he was attending his office at Jorhat by boarding a bus cannot be accepted without cogent and unimpeachable evidence. From the evidence so and so, it is established that the alleged accident occurred due to rash and negligent driving of both the vehicles, causing death to so and causing injury to so and so. A tribunal or a trial court, how much is required? It is established. How much is required? On 3 parts, tribunal has accorded.
No, that is there.
There is no finding. You are saying that you have made me to look again in the judgment.
No, because, my lord, all the cases were clubbed together. Therefore, court has come to a, my lord, conclusion, my lord, by taking all the cases together.
Yes,
I-
what to
be-
do?
because,
What
my
to
lord,
do? Separate
that
judgment will be.
Okonmani
You
Das
should
case-
have, you
yes.
should have appealed that.
Yes.
All these points will not be.
Because, my lord, in Okomani Das case, my lord, there from the perusal of the claim petition, even not a single allegation against this offending scooter, my lord. And also in the, my lord, evidence also, my lord.
As a whole, Mr. Seven claimants have deposed. Then you deposed. On the basis of analysis of those evidence, court has recorded these findings of fact, right? And then you sat silent. I would have accepted that you are a very layman cultivator. Right. All this could have been fitted into your submission. That I am a layman, cultivator, illiterate, poor,
Signed on the dotted
poor,
lines.
the BPL,
On that point, my lord, Lordship is correct.
BPL person. I don't know. You, everywhere you have entered into the witness box. Then you know it is a contested case. You file written statements. When you deposed, by entering into the witness box, you were cross-examined. It is not a case of perverse finding.
No, my lord,
It
why
cannot
am-
be, Mr. Dotto. Tell me what is perverse finding?
My lord,
What is the understanding of perverse finding?
my lord, perverse finding is that, my lord, suppose, my lord, if the judgment is not-
Absolutely nothing. When there is absolutely nothing in evidence and court has recorded a finding, to the contrary,
Yes.
that is perverse finding.
Yes.
Is it not?
That is true. That is then, my lord, why I am saying so, my lord, it is perverse, because, my lord, in several cases.
This does not fit into your submission in the absence of any appeal and in the with the invoking the provision of Order 41, Rule 33.
My lord, what I am just want to point out, my lord, in several cases, though, my lord, liability has been in all the 7 cases, liability was imposed.
Case basis.
Yes, my lord, but in case-to-case basis, my lord, all the claimant has not, my lord, alleged against me, my lord. Even Okonmani Das case also, my lord, he was not. So,
No, that is why. If you want to make more analysis, I have read already.
Yes.
I have read the testimonies of 2 witnesses now.
Yes.
I'll answer your question. I'll answer your testimony. I have read also.
No, yes, my lord. But
Yes,
what
your
about
testimony as well as
yes,
testimony of 2 witnesses I have read. In the meantime, I have read.
No.
I'll refer to that.
And those are the best witnesses, my lord. They were injured,
No, my
The
lord.
shopkeeper also.
my lord.
My lord, in the FIR, my lord, there is no mention of, my lord, my motorcycle, my lord. And they have not even, my lord, exhibited the, my lord, charge sheet, my lord. No seizure list was.
I pay to lawyer.
So
Whether
if you're.
these kind of submissions can be made under Order 41, Rule 33. I have forgotten the decisions, so let me have the services of SCC online. I don't think this submission can be made. Come up, I may not finish today.
My lord may give me.
There is a possibility.
My lord may give
Sir,
me a sense.
I have very less memory. I'll start dictating whatever I have read. If it is possible that it does not end, it will spill over, then you will get the opportunity. Otherwise, 7 appeals, it is very difficult to handle. Order 41 to 33.
My lord, my respectful submission is that my lord may allow me at least 1 day or 2 day time, my lord. In the meantime, I will file an affidavit. I will file a written synopsis of my argument, my lord.
If I, that is what I said, Mr.
Yes.
Doctor.
Yes.
If it does not end,
Okay, yes, ma'am.
most likely it will not end. Then we'll get the. And মঞ্জুর এইটো পাহৰি নহয়। So if your submission is accepted, who will be liable?
Hello?
Who will be liable? Personal insurance
no,
or
the owner of the offending truck. Owner of the offending truck.
all these seven appeals.
Seven.
All these 7 appeals are referred under section 173 of the Motor Vehicles Act 1988, as amended, against a common judgment an award dated 18/7/2012 passed by the learned member, Motor Accident Claims Tribunal, within bracket tribunal, Golaghat, in 7 number of applications preferred under section 133. Oh, sorry, 166. 166 of the motor vehicles of the act, right? The act. Full stop, para. What are they? Formal. The claimants the particulars of the motor accident claim cases, comma, the claimants and the region for which the claim applications were filed are mentioned herein below in a tabular form. So the name of the deceased or the injured, comma, as the case may be, comma, are also is also mentioned in the table. Para. Apart from after case, after table, below table. Apart from the claims for death or deaths or injuries, comma, in 3 of the applications, comma, claims were made also for damages caused to properties. And that is in MSC case number, your document. Well, that is MAC case number 256/2004. One perhaps. Oh, sorry, 244/2004 and 256/2004. And which one? Romanando Das.
Lordship is asking about the damage to the property, injuries.
No, damage to property.
Damage to the properties.
Mohan Soikia. Mohan Soikia.
One is 256, 2004.
That is done. And 244.
244,
Mohan Soikia.
2004.
Sanjeev Hiloidari, nothing has been awarded. Nothing has been awarded. He asked for injuries. Okay. Kamal Hiloidari.
Kamal Hiloidari.
244, 2004. Record here from Mohan Soikia. 256, 2004. Kamal Hiloidari.
And 227, 2004.
Okay. 227, 2004. Ramananda Das.
Ramananda Das.
But you say Sanjeev Hiloidari.
Sanjeev Hiloidari is an injury. 257, 2004.
Where?
And 3 cases are death cases.
That I agree. From the materials on record. Now it is the case of the claimants that the accident occurred at about 8:40 a.m. on 9/5/2023. 2003 between two vehicles. Roman 1, a truck bearing registration number AS-04/4271 and motorcycle or scooter?
Scooty, LML scooter. Vespa. It was a
Scooty.
Malad, here it is used
He
scooter.
says
Malad.
motorcycle.
No, somewhere it is written.
He says motorcycle. A two-wheeler.
Two-wheeler.
Bearing registration number AS-06/B-6286. Full stop. In the claim applications, it was alleged that in the claim applications, it was mentioned that the place of accident was near a bus stop.
Bus stop.
Bus stop, Malad.
Bus stop
Rongagora
at Rongagora Tiniali on National Highway number 37. First stop. It was alleged that
37.
37.
Yes.
It was alleged that when the truck was proceeding from Dergaon side towards Bokaka town along the National Highway 37 in a ration negligent manner, the two-wheeler which was ahead of the truck, also driven in a ration negligent manner. Ration negligent and zigzag manner. Without making any room for the truck to overtake it. Full stop. It was alleged that when both the truck and the two-wheeler reached Rongagora Tiniali. The two-wheeler abruptly turned to the right side without giving any signal to the truck behind. Full stop. The accident had occurred in the process when the truck, in an effort to save the two-wheeler, had to turn on the other side. Full stop. As the truck could not control its speed, it knocked down the standing passengers waiting for bus at Rongagora Tiniali. Full stop. Para. The claim applications, it was mentioned that as a result of the said accident, three persons, that's Lakshmi Gupta, Ranu Dole, and Kulamon Das, that's sustained serious injuries on their persons and died instantaneously on the spot. Three other persons, that's Ramananda Das, Sanjeev Hiloidari, and Rontumoni Hoikia, minor son of Mohan Soikia, that's also sustained injuries on their persons. Full stop. In the claim application, filed by the claimants, there's Mohan Soikia and Kamal Hiloidari, damages were sought for the compensation amounts were sought for the damages caused to two shops at Rongagora Tiniali. Three pawn shops belonging to those claimants at Rongagora Tiniali, along with the stocks and provisions therein. First of all, the materials, the materials on record point out that after registration of the cases, notices were issued to the opposite parties. Arrayed in the claim applications, the opposite parties where the rider of the two-wheeler within bracket Nigam Sondro, Madam, and the insurer of the two-wheeler within bracket Messrs. New India Assurance Company Limited. Bracket close. Comma, the owner of the truck within bracket Bimal Kumar Bora, comma, the driver of the truck within bracket Hemo Sohan, and the insurer of the truck within bracket Messrs. National Insurance Company Limited. So the insurer of the truck, comma, Messrs. National Insurance Company Limited is the appellant in all the 7 appeals hearing. Close to para. All the opposite parties, after notices were served on all the opposite parties, comma, all of them, comma, except the opposite party number 6 in MSC case number 163/2003, comma, contested the cases, claim applications by submitting their written statements separately. Full stop. On the basis of the pleadings, comma, the tribunal framed 2 issues for determination, and they were, that is 1 and 2. Para, during the course of the proceedings, the claimants examined themselves as witnesses in respect of their claims and exhibited a number of documents. First off, from the opposite parties, comma, the owner and Roman alias rider of the two-wheeler Bigam Sondro Medo bracket close stepped into the witness box and gave his testimony, and he was also cross-examined by the claimant side and other opposite parties.
National
You examined?
Insurance, we examined 2 witnesses.
No, he was cross-examined
Yes.
by claimants and
My lord, claimants are examined and the driver and owner of the offending truck also examined.
let me see that.
New India.
By the 2 insurers, by the claimants and the 2 insurers.
And also by the owner of the truck also. OP number 2.
New India did not cross-examine. New India did not cross-examine.
The number 2.
OP number 2 is the owner of the driver of the truck,
No,
and OP 5
he is
is
branch
New India.
manager. Branch. And OP number 2, OP number 5. You cross-examined. And you elicited that.
Yes, we had done.
Now I think I am more prepared than you.
No, but I was I was pointing out that New India did not.
by
consider.
the
I am
by
national
the
insurance.
claimant, comma, the two insurers of the two-wheelers and of the two-wheeler and the trust and other opposite parties. From the insurer of the truck, from the side of the insurer of the truck, two witnesses were examined. Mr. Dr. Saraf, you have any case? I don't think these seven appeals. Okay. Huh? 18. These are 2012 matters. And there has been a directive from the Supreme Court.
As per your lordship permitted.
If somebody is there, we'll try to fix it. You need not be here. You need not be here. Close. দুজন witness বুলি ক'লো ন? Who also exhibited two number of documents. First of all. By sorry, the tribunal in respect of issue number 1, comma, the tribunal reached a finding that the accident was caused due to rash and negligent driving of both the vehicles, resulting in deaths of Ranu Dole, Lakshmi Gupta, and last one,
Kulamon Das.
Kulamon Das, Kulamon, Kulamon Das, and on the spot, and injuries to Romanando Das, comma, Sanjeev Hiloidari, and Ranju Soikia. The tribunal had thereafter proceeded to determine the question whether the two offending vehicles were under insurance coverage at the relevant time of accident. Full stop. On the said aspect, comma, the tribunal reached a finding that the two-wheeler was not under any insurance coverage at the time of the accident, and therefore the owner of the two-wheeler would have to bear the liability. So the tribunal had exonerated Messrs. New India Assurance Company Limited, comma, who was impleaded as the insurer of the two-wheeler. Post of.
insofar as the insurer of the truck is concerned, comma, the tribunal, after considering the evidence on record, including the two exhibits and two decisions cited at the bar, comma, held that as the insurance policy for the truck was issued at 6 p.m. was issued a cover note showing the date of commencement of coverage from 6 p.m. onwards on 9/5/2003, and the accident had occurred at 8:40 a.m. on 9/5/2003, comma, the insurer, comma, National Insurance Company Limited, that is the appellant, cannot escape the liability post of holding. So, the tribunal has held that the claimants will be entitled to get compensation from the owner of the two-wheeler and the insurer of the truck. Full stop. On the second issue, the tribunal had thereafter proceeded to determine the quantum of compensation in each of the claim applications separately on the basis of the evidence laid by the parties. Full stop. After analysis of the evidence on record, comma, the tribunal proceeded to award following compensation amounts to the claimants. MSC case number ইমান ফিগাৰটো আছে 2 লাখ তেনেকে গোটেইকেইটা দিয়া আছে। Finally, comma, while disposing of the claim applications on contest, all the 7 claim applications on contest, the tribunal decided both the issues against the insurer of the truck and the owner of the two-wheeler, respectively, apportioning the liability at the ratio, comma, 80:20. So, the meaning thereby, comma, the insurer of the truck was, the insurer of the truck was thereby directed to pay 80% of the awarded amounts to the claimants in their respective claim applications while the owner of the two-wheeler was directed to pay the remaining 20% of the awarded amounts to claimants in all the 7 claim applications within a period of 60 days from the date of the judgment and award dated 18/7/2012, along with interest at 6% from the date of filing of the claim applications till realization of the entire amount. Para. Agreed by and dissatisfied with the direction to pay 80% of the awarded amounts in all the 7 applications as the insurer of the truck, which was found to be one of the 2 offending vehicles involved in the accident, the insurer as the appellant is before this court by the present 7 appeals. Yes, this is the fact. I have heard Mr. R.K. Patra, learned counsel for the appellant. Everywhere parties are same?
Almost same.
Almost will not do.
All same.
I am respondent
Same?
number 4 in all the cases.
My lord, in
Chief, I am respondent number 5 in all the cases.
All.
Yes, sir.
And you are
4.
Mr. M. Dotto, learned counsel for the respondent number 4 for the appellant. That is the insurer of the truck. Absolutely. Mr. M. Dotto, learned counsel for the respondent number 4. That is the owner of the two-wheeler, and Miss
P. Bhattapur.
B. Watergood, learned counsel for Matters New India Insurance Company Limited, who is insurance company limited, who was impleaded, which was impleaded as the alleged insurer of the two-wheeler in the claim applications before the tribunal. The claimants, the claimant in each of the 7 appeals, the claimant in a claim application, expert, in each of the 7 claim applications are arrayed as respondent number 1 in the present 7 appeals. Full stop. The owner and the driver of the truck are included as the respondent number 2 and the respondent number 3.
may I point out one thing here?
Were impleaded. I've been impleaded. Are stroke. Technically, the owner of the truck was impleaded originally as respondent number 2 in these 7 appeals. Full stop. As the owner of the truck expired during the pendency of these appeals, the legal representatives of the owner of the truck were brought in as respondent number 2.1 or 2.1, 2 in bracket 1, and respondent number 2 in bracket 2 respectively. Full stop. The driver of the truck is implemented as respondent number 3 in all the present 7 reports. Full stop. Para, despite service of notices upon the aforementioned respondent number 1, comma, respondent number 2, comma, 2 within bracket 1, and 2 within bracket 2, and the respondent number 3. They opted not to participate in the proceeding by making appearance. Post. Para. The main plank of submission of Mr. Vatra, learned counsel appearing for the appellant, is that the learned tribunal had misconstrued the provisions of Section 147, Motor Vehicles Act, and Section 64 EB of the Insurance Act 1938. So stop. It is his contention that when the cover note specifically mentions the date and time of commencement of insurance coverage, comma, there cannot be any other interpretation of the insurance contract. In the case in hand, it has clearly emerged from the evidence on record that the accident took place at about 8:40 a.m. on 9/5/2003, and the cover note was issued by the appellant insurer stating specifically that insurance coverage would commence from 6 p.m. onwards on 9/5/2003. First, there cannot be any question in such fact situation, comma, there the aspect whether the aspects like there cannot be any issue regarding cancellation of the cover note. Subsequently, the tribunal had erred in going into the aspect
regarding commission of fraud by the owner of the truck in getting the insurance coverage by suppression of the fact of accident and non-cancellation of the cover note by the appellant insurer at a subsequent point of time after getting the knowledge about the accident. Full stop. He has further submitted that the decisions referred to by the tribunal in foisting the liability on the appellant insurer are not applicable in view of the clear evidence on record that the insurance coverage, commencement of the insurance coverage was much up, though on the was to commence subsequent to the time of the accident. So, he has further contended that the appellant insurer is to be extricated from the liability, and in such a situation, it is the owner of the truck who is to be held liable for payment of the compensation amount as awarded by the tribunal. Post of years as awarded by the tribunal. Yes. In support of his submissions, Mr. Bhatra has referred to a number of decisions of the Honorable Supreme Court of India, which will be referred to, which will be referred to in the later part of this judgment. First up, Miss Watagur, Learned Counsel appearing for the respondent number 5, has submitted that the tribunal has already held that Messrs. New India Assurance Company was not the insurer of the two-wheeler, and the owner of the two-wheeler, that is the respondent number 4 herein, has not preferred any appeal, no liability can be no liability can be, no direction can be made against it as an insurer of the two-wheeler. The relief decision. The tribunal has already relieved Messrs. New India Assurance Company Limited from any liability in the accident, as at the relevant point of time, the two-wheeler involved in the accident had no insurance coverage. Para Mr. Dr. Learned Counsel appearing for the respondent number 4, that is the owner of the two-wheeler, has submitted that though no appeal has been preferred by the respondent number 4 in any of the against the against the common judgment and order dated 18/7/2012, passed in the 7 claim applications, yet, the case of the respondent 4 as the owner of the two-wheeler can be examined under Order 41, Rule 33, Code of Civil Procedure, 1908. According to him, the finding reached by the tribunal that there was rash and negligent driving on the part of the respondent number 4 as the rider come owner of the two vehicle was perverse. Full stop. The tribunal did not take into consideration the stand taken by the respondent 4 in his written statement as well as in his testimony to the effect that at the relevant point of time, he was not riding the two-wheeler and therefore the question of driving a two-wheeler in a rash and negligent manner on his part could not arise. Full stop. Yes. What more?
Malad, that is, Malad, finding is unsupported by cogent and reliable evidence.
Perverse.
Perverse.
I have already said.
That is it.
Better. I have gone through the evidence stroke materials on. I have duly considered the submissions of the land council for the parties, and I have also gone through the material stroke evidence on record from the case records of the 7 MSc cases from my origin. Almost 4:30. We'll start a fresh innings. Over here, sir. Ready? Part hurt, so you can keep it. Yes. All these ayahs are of no value if your appeal is decided. Yes. Find out in the meantime you have paid the money or something. Any cases. I'll check. Okay. I'm going to do a hard put. You were there. Huh?
You in this case.
Party, no, no, she's not in this.
I'm telling you, at least these appeals also so as partner. And the appeal should be taken up at 2 p.m.
When, madam?
2 p.m.
Madam, on this date? On this date, madam?
Day after
13,
tomorrow.
1308.
30.
13.
Day after tomorrow.
Day after.
2 p.m. Part heard. This point.
Yes. I thought 14th I am leaving for plant release.
13. Anyway, you have been hard. Give
Well,
somebody here.
May I be permitted to take the handwritten chart and I'll type
Please,
it and bring
please,
it?
please.
I'll.
You give 2 chart.
Yes, ma'am.
MSC case number, 1 column. Second column, claimant name. Then disease, next column, disease or injured. And region for claim, 4th column. So there you write wherever that for death, wherever it is there, injuries, wherever it is there, damages to properties.
And if lordship permit, then I can place one also synopsis of my. If lordship permits, my lord.
Anything, but you cannot go beyond record.
Yes,
If you
yes,
want,
yes.
Give something on 4133.
Yes, yes. Then I will give.
Otherwise, all this I have read. Your evidence, I have written
Yes.
statement, I have read. Your testimony, I have read. Your cross-examination in 2 cases, I have read. Right?
Yes.
And the tribunals has privacy recorded the finding regarding the testimony in a proper manner. It has not exaggerated anything. And that is a fact that in 213, you admitted.
That is there. That is there. Don't have any insurance coverage that I admit.
There is nothing that you live like that. For 12 years, you are enjoying. Is it not?
Yes, yes.
You are not paying a penny. Okay then. Day after.
13th, madam. I'll also take the copy of policy photocopy which I have. I'll
sure.
submit it along with the
Sure.
chart. madam.
एक ही रखेंगे पहले क्या रखेंगे बताइए
On 13th, madam, I'll produce.
Yes, I have heard that Mr. Batra,
My lord.
I have heard that Mr. Raju Goswami
Yes,
bereavement-
yes, my lord. He's expired. 37-year-old.
Yes, how?
It will prolong.
Some disease.
Yeah.
What is the matter about Mr. Kosik?
Lordship, the matter is about seizure, Lordship. of
Seizure.
Jewelry.
2014 matter.
14, Lordship.
14 meter, my lord.
Silent they দিব পারি How long you will take, Mr. Kosik?
Lordship, an hour, Lordship.
My lord, this matter will require some hearing, my lord.
Can it be on the 3rd of September, your Lordship?
Silence. Yes. Eighth of September?
8 September কোম্পানি পিটিশন কেটে আছে
10. A Kosik Learning Council for the petition. Petitioners. And Ms. H. Gorwal and counsel on behalf of Mr. B. Go Standing Council Finance and Taxation Department Government or some for all the respondents. So RW is there. Who is? Is for whom? Yes, Sopur and parties. These are the cases. Ah. 10-9. 2026. Any interim order?
Lordship,
No. The interim orders from wherever passed earlier shall continue till the next.
highly obliged, your lordship.
Yes, Mr. Rahul
Obliged,
is
my
there.
lord. Item 18.
Rahul is gone. Okay, then no order is to come.